In jail that I have not talked to.
And I'm sorry, your name is Amy, correct? Excuse me, your name is Amy, right? Okay, thank you. All right, everyone. Happy Friday. So we should be excited because it is Friday. So here are the rules. One, in the 187 District Court, I don't care whatever court you've been into, I require that everyone treats everybody with respect, everyone treats everybody with kindness. And if you don't feel that way about someone, fake it. So today we don't have our normal court reporter, we have Amy. And Amy this may be her, I think this is your first time coming to Bexar County?
No, it's not.
Yes.
I'm still pretty new.
Yes, she's pretty new. So we're going to make her job very easy today so that she will enjoy the profession that she's in because she's fairly new. So what we're going to do is we're going to speak up so that she can hear. We're not going to talk over each other. We're going to talk one at a time so she'll feel like she's chosen the correct profession. And then when she goes to another court and everybody's talking over each other and whispering, she'll wish she was in the 187. So I'm going to call the docket. And when I call the docket, I need you to let me know you're here. If you don't respond, I'm going to assume you're not here and a warrant may be issued for your arrest. And for everybody on the front row is for people who are late. Front row is for people who are late. All right, Damone Wyatt. Billy Freeman. Yeah. In custody, we have Andres Menchaca, Danny Acosta, Kimberly Marsh, Carlos Martinez, Malik Baloo, Matthew Cole. Matthew Cole. We're not starting off with a Good Friday. In custody, we have Donald Gilliland, Ruben Rodriguez, LaDonna Worthy. Are you related to James Worthy? Do you know who James Worthy is? All right. So where are my basketball fans? All right. In custody, we have Cheyenne Fox, Jose Gonzalez, Mario Pineda. Thank you. Gracie Segunda. Thank you. I know I'm mispronouncing your last name. When you come forward, you'll tell me how to pronounce it. In custody, we have Mike Perez, Priscilla Sosa, Caleb Coleman Lee, Jessica Medina, Anthony Villarreal, Alejandro Espina. If there's a Nicholas Herrera here, your case has been closed. Javier Medina. In custody, we have Frank Garcia, Damon Thomas. Here. Thank you. John Ayala. Thank you.
He's present, Your Honor.
Thank you. How do you pronounce this next person, Deputy Laura? Thank you. Fernando Zepeda. Dan Valadares. Thank you. Juan Davila. In custody, we have Kavan Rangel, Judah Castilla. Oh, he's by Zoom. And State, if you'll call Mr. Cisneros, Cisneros is by Zoom too, and if you can confer with him by Zoom. Well, that'll be sexual assault side. Francisco Aguilar. In custody, we have Nathaniel Mackey, David Gallegos, Rudy Gonzalez, Johnny Tejeda. Johnny Tejeda.
I'm here for him, Judge. I will get him here.
All right.
My best.
Thank you. Mike Christopher Pettis. Mike Christopher Pettis. Francis. Oh, he's in custody. Thank you. Francisco Reyes. Rosalie Morales. Gilbert Arcorta. Anthony Villarreal. Anthony Villarreal. Roland Hernandez. Gloria Orozco. Esperanza Marino. Esperanza Marino. Fernando Zepeda. Justin Campbell is in custody. Dante McCoy. Sir, you need to take off your cap. Crystal Cherry is in custody. Daryl Masters. Jason Hickman. Gabriel Oriana.
Judge, you should be in custody.
Yes, he's in custody.
Thank you.
Henderson Session. Henderson Session. In custody, we have Michael Kildor, Jacqueline Wood, Christopher Island. All right, thank you. Carlos Vargas. That's just a motion. In custody, we have Mariah Lopez, Leo Gonzalez. Leo Gonzalez. In custody, we have Thomas Ali, Carlos Romero. The attorney for Dario Escalante, Escalante. Thank you. And that's just the motion to return property.
Yes, Your Honor.
All right, Manuel Rodriguez. John Gonzalez in custody, Daniel Ortiz. Daniel Ortiz. Find a seat. All right, is there anyone who came in late or your name was not called? All right, we'll start here. What's your name, sir? Which page? Did you come in late? All right, you need to go on the front row. Anyone else on this side who's on the docket? All right, unless those are prescription glasses, you need to take the shades off. Yes, over here. Do you know who your attorney is? Do you know your SID number or case number? 849-823. All right, just have a seat. We'll get with you. Yes. Glandon, how do you spell that? All right, do you know your attorney's name? All right, do you have a SID number?
I have no idea.
Do you have a case number?
I do. I'm not. I don't know. Off the top of my head.
All right, just a moment. Anyone else over on this side? And who are you here for? I'm sorry?
Judge, I have something that I was going to tell you about, but they're here.
Okay. All right, just give me one moment, okay? And I'll take that matter up. All right, anyone else? Family violence? Johnny Cisneros is on Zoom. If you could call him and confer with him by Zoom, and his client is on Zoom as well. All right, thank you. All right, these are the rules of the court. As you can see, it's crowded. So we want to do things orderly. And as you can see, we have two prosecutors, only two prosecutors. So we're going to put some patience in our pockets today, and we're going to take it out as needed, and we're going to share it. So this is what you need to do, attorneys. Just grab your file, whichever box it's in, place it on the table. Do not surround and stand in line for the prosecutor. Just place it on the table. They're going to take you in the order in which they receive your file. So first will be first and last will be last. Last will only become first if you all want last to become first. Then once you have conferred with the state, conferred with your client, then just come up here to the clerk. They will pull your file. They will put it here again, then take your seat, and I will call you in the order in which I receive your files. First will be first and last will be last. If you have a client who's in custody, because as you can see, even though we have deputies here, we have a lot of people who are in custody. Once you ask for your client to be brought out, do not leave the courtroom because that's going to mess up with logistics for the deputies. And we want them to have a good day today too. All right. So if you have an interpreter and your client doesn't speak English or English is their second language, they need an interpreter. Before you approach, ask for an interpreter to be called because I'm still going to want to speak to them in their native language. And again, there's a shortage of interpreters. So once the interpreter is called, do not leave because when that interpreter comes in, I'm going to have to take them right away. And that's the only way last will become first if the interpreter is here because they have over 20 odd courts to respond to. All right, everyone, it's Friday. Let's remember that and let's have a great day. Please confer. And can I see pretrial services? Can you mute us? Okay.
So let me reconcile, do you wanna?
Yes. All right. Thank you.
Oh,
Okay. Thank you. Good morning, Johnny.
Good morning.
How are you doing?
Doing fine, thank you. Just here, waiting for this hearing on the, the discovery. How are you?
All right. Everyone, could you make sure you whisper, please? So Johnny, we are, busy in court as always, but what's going to end up happening so that the state can confer with you, they're going to call you on your phone, okay?
Okay, thank you, but I think I did get all my discovery, Your Honor.
Oh, you got all your discovery?
I
Just give
believe
me a
I did.
moment. Okay. And your client is here on Zoom as well.
I told him to be, I didn't know if he needed to be. So since they're gonna call me, should we go ahead and just log off?
No. Just give me one moment, okay?
Thank you.
All right. Thank you.
Is Johnny supposed to confer with us? or-
No, it's with them. And let me give you this. You come here and you're like, I'm extra busy.
The condition that we would need for the pay it forward would be 4942.
Just 1 second. Let me go there.
Yes.
Oh, I can see Genesis Yarrow's file. It's Judah Castillo. And could I see, is Jose Rodriguez here? Come forward. Everyone needs to whisper. So, Mr. Rodriguez, do you want to just do your time and go to the Bexar County Jail? Everyone needs to whisper. Do you want to just do your time and go to the Bexar County Jail? That's my question for you. So you can go to jail for up to 1 year. That's what you all agreed to. I'm sorry, no, 210 days is what you all agreed to. So do you want to just go to the Bexar County Jail and do your time? So why are you not doing what's required of you? You're not doing your drug testing. Why are you not doing your drug testing? No, they say that you're missing your drug test. So here's the thing, when a drug test is required of you, you can't go whenever you want to. Do you understand? So what I have here, and if it's not true, let me know if it's not true. They say that you failed to submit on November 4th and didn't report as scheduled on December 5th. So why did you not submit on November 4th? And why didn't you submit on December 5th?
I was only asked to submit at one time.
When you're drug tested today, what are the results going to be? Because you're giving me a UA today. All right, I'm going to want a drug test from him today. You're not to leave the courtroom until you're drug tested today. You understand? And what else are you doing? What is your work?
My work.
Yeah.
Auto home.
And how's that been going?
All right.
What do you mean? All right. Are you reporting to them on time?
not gonna waste your time, miss. I'll just rather do my time.
All right, so what is your drug test gonna be? What is it gonna be today? For what?
Heroin.
Now, was that hard? So why you been using?
Whisper.
Hmm?
We don't have a good excuse.
All right, so here's the thing. I am trying to help you, right? And I know sometimes people say, Judge Boyd is too hard, but I'm trying to give you the help that you need. If I send you to the Bexar County Jail for your 210 days, yeah, you'll go to jail, you'll get out, you'll be done, but you're going to still have a heroin problem. And that's an issue, and we need to take care of it. So the question is whether or not you want to get help for your heroin problem. That's either yes or no. You just want to continue to use?
I don't think it's done. Rare that I use it. In a long time.
I mean, it hasn't been a long time since you used it if you're going to be positive. So how often, and I want you to be honest with me, you're not under oath, but I need you to be honest because you have CPS compliance. I have that on here. So that means that you have a child, right? So how many children do you have? You have 3 children. What are their ages?
7, 6, and 5.
All right. Do you want to be in their life? Do you want to be in their life clean and sober? Or you want to be in their life as someone who's using heroin? So when's the last time you saw your children? And I will tell you this, people think that children don't know what's going on, but I'm sure they can tell the difference between their dad when he's clean and sober and when he's not. And is Child Protective Services involved? So where are your children now?
With their baby mother.
All right. Not baby's mother.
Okay.
Mother.
I'm nervous.
That's okay. There's no need to be nervous. Here's the thing, and in this court, when people need help and want help, and the community is protected, I try to give them help. I can send you to the jail, and you know what I could tell them? I could tell them, I want you to do the 210 days flat. Or I can try to get you help, right? And I can tell you what help is going to involve. Help is going to involve you in intensive outpatient treatment. And you're going to have to get a handle on this problem. Help is going to involve you doing 90 sober meetings in 90 days. That's what help is going to involve. So either you want it or you don't. So, and here's the thing, you can't just, whenever some problem crops up, you can't just do a fallback, I'm using drugs. You understand? So you're going to still get a UA today because I want to see where you are with regards to your drug use. And I don't know if you all still need to do a tap, but he needs to be in treatment.
He hasn't touched it either, like his case as far as for this claim.
All right. Just one moment. All right, we're going to have to extend him. I'm going to extend you a year. All right. And so what I want done is I'm going to want you to do 90 sober meetings in 90 days. They're called sober meetings, but it's really your NAAA meetings. You can find that throughout the city and they are available 24/7. So whenever you think about using, you need to go to one of those meetings. And you can do that meeting in the morning, afternoon, whatever time. And if I'm just going to require you to do 90 meetings in 90 days. But if you feel like you need to do 200 meetings in 90 days, whatever you need to do to maintain your sobriety, you should be doing. You understand? So if you need to go to 3 AA or NA meetings a day, then do it. That's not going to result in you being extended further or anything like that. But you have children who are depending on you. They're dependent on you for financial support. They're dependent on you to be a role model. And if you don't get a hold of this drug issue, you're not going to be any good to them. And slowly you're going to start wasting away. You understand? So when is the exact last time you used heroin? All right. So have you been suffering withdrawals or anything? All right. So don't use heroin anymore. Because the last thing I want you to do is end up on, what's the drug? No. What they give you in exchange for heroin. Yes. I don't want you to end up on methadone. People praise methadone, but I've had clients who've been on methadone and they just still are drugged up. And it's still the blank stare. Then you're trying to wean them off methadone. All right, so this is what I'm going to do. I'm going to alternate amend your conditions. Extend 1 year. I'm going to want 90 meetings in 90 days. Is there any way to move his TAP evaluation up? All right, can they still have him in intensive outpatient treatment? He really needs it. All right, and is that a price associated with that? Because how much is that? Can I waive that? Or can we defer it? I'm sorry, I can't hear you from back there.
So for cats, we can't tell cats that certain someone would have the right of funds. Probation does not have the funds to register into cat. However, through outpatient treatment with probation, the TAP would allow to see if it needs criteria to get that treatment for free.
All right, so what I'm gonna do is I'm gonna do intensive outpatient treatment. And we're gonna see if we can get it through probation.
Yes. If there's any cancellations, we can see if we can fit them in that spot.
All right, so we're gonna do intensive outpatient treatment. Here's the thing, in this court, communication with your probation officer is key. I want you to do well on this probation. I want you to be clean and sober, but you've got to, take the first step. You understand? All right, so they're going to give you a UA today, and it's to see where you are. And then probation, if he's positive for marijuana, we're going to need to start having him tested for levels.
Yes.
All right. And see if we can defer his fees until he gets on his feet. Because he's saying he's having problems paying for the UAs or whatever. Yes. Okay. Is there anything else you need help with?
All right.
All right, you better get it together. All right, thank you. All right. Yes, it does. I was checking to see which ones don't have a bond. Let me see what this charge is.
No.
Yes, I mean, just because I require everybody to refer their rights and state rule number 20.
Yes, ma'am.
All right, thank you. You're welcome. You're welcome. I mean, if they want to, but I'm. Oh, that's a fine question. Oh, no, not really, but I'm gonna talk to them about it. Okay. All right, this one is done. Oh, here you are. I think that's the one I just did. All right, Gracie Sugunda and Mario Pineda. Come forward. Oh, there's a line there.
I'm with
Huh?
Subinda.
Oh, no, there's a line. You see the line right there? You need to be behind it.
Jeff. Hey, Jeff. is this on the record?
No, you'll know I'm on the record because I'll call the case number. Hello, good morning. Is there a prosecutor here? This is Segundo and Pineda. Is this criminal trial division?
Yes, sir.
All right.
We spoke.
All right. So are you the attorney for both these parties?
I think the attorney records here, legal, but I'm with him, with his firm, I'm Edmund Carroll.
So, you're representing co-defendants? One attorney?
Yes, sir.
You don't see that as potentially being a conflict that you're representing co-defendants?
I was the one who took the case, Your Honor.
So who represents, who's,
Well, the firm,
and who's the attorney from the firm who's representing them?
myself, Javier Oliva, Bradley Bellows.
All right. So, what's going to need to happen is they need to be aware if there's a conflict. And there needs to be some documentation of the conflict, because let me just explain something to everybody. This train is leaving the station, right? So either it's going to end up with a dismissal or a plea or a jury trial. And if we get to the point where it's a jury trial and they have diverging defenses or defenses against each other, or somebody wants to do a plea and in exchange for that plea, this person has to turn on the other person. We're not doing this thing where, oh, now I want an attorney and oh, now I want a different attorney. So there needs to be.
Your Honor, I'm not sure if they came to, if they were.
Well, no. Here's the
Yes,
thing.
sir.
I do not, and I am not trying to interfere with any attorney-client relationship. But what I'm just putting everybody on notice is that the same attorney representing co-defendants on a case that's an aggravated assault, serious bodily injury, where based upon just what the charge says, you may be looking at 20 years in prison. I'm just putting that out there.
Yeah, they talked to us about that.
So that's where we are. And I'll make a notation in the file that everybody's aware of that, but there needs to be something probably in writing stating and on file with the court.
Okay, I'll follow whatever.
All right. So where are we on this case?
He asked me to review it for a possible offer. I just got the file today, so I have not had adequate time to review it, but
Okay.
I can review it for an offer.
All right. So you want to look at the file and see? Are you able to look at the file today?
Yeah, I would say I would, but it would be after some of the pleas that I have going on.
Okay. All right. So just remain in court. They're going to look at the file and see if they can tender an offer to you. Then we'll come back.
Okay.
All right, thank you. All right. All right, Johnny Cisneros, thank you so much for being patient.
Yes, ma'am. Your Honor, I just spoke to Michelle and I believe that I have all the discovery. I believe
Okay,
I received it all.
all right. Johnny, have they made an offer to you or no?
I don't have the file in front of me, Your Honor.
All right. So what we'll do is we're going to recall this in 30 days, and in 30 days, the state has to have made an offer, okay?
Yes, ma'am.
Ms. Ferguson, I need a 30-day reset on Castillo. All right, so Mr. Castillo and Johnny, that's going to be on January 23rd at 9 a.m.
Okay, yes, ma'am.
And is your client out of town or out of state or something?
No, ma'am. He's in San Antonio.
All right, so Mr. Castillo, on that day, you'll need to be present in the courtroom. Do you understand?
Yes, Your Honor.
All right. Have a great day. Happy Friday.
Thank you.
You're welcome. Bye-bye.
Judah, you can log out, son.
Yes, sir.
Bye-bye, Your Honor.
Bye-bye. All right, thank you. And what page is Castillo on? All right, thank you. All right, thank you. All right. And there's that file that's done. All right, we're going to take up Valadares, and then we'll take up Jacqueline Wood next. Who's here on Valadares? And if we could have Valadares come forward. Hi. It's always great seeing you. You always bring joy to the day. My mom always talks about you. Yes, she thinks you're fabulous. All right, so this is not on the record. Counsel, has your client had a chance to speak with the immigration attorney?
We have, Your Honor.
All right, and do you have, has he received his letter and he knows what will happen?
Yes.
Okay. All right, have you received, I know we had a plea deadline date, but the court moved that plea deadline date so he could speak with his immigration attorney. So has the offer changed or anything, or is the offer still the same? All right, so is your client needs time to consider that offer?
No, no, that's time to consider. For us to be placed on trial.
All right, so Mr. Valadares, are you rejecting the state's offer?
Yes,
Are you requesting a jury trial?
yes.
All right, state, how long do you all think this trial will last?
2 days.
All right, Ms. Ferguson, I need a jury trial date on Daniel Valadares Rodriguez. It's special crimes or family violence. It used to be called special crimes.
It's called special.
Yeah. And then I think criminal trial division got jealous of us with that name. They're like, can't we be called something?
Thank you.
All right, your jury trial date will be on January 17th. you'll need to be here in this courtroom at 9 a.m. And counsel, if there's anything that the court needs to review, any videos or anything, or any issues that I need to take up, let me know that before trial. All right. Is there anything else? All right, Ms. Ferguson, we'll give you your reset form. All right, thank you. Have a good one. Thank you. All right, who are the parties on Jacqueline? Oh, yes, yes.
Mom, I just with she knows me.
Yes.
Cool.
Oh, she watches every day.
I love her.
Oh, I'll let her know. Yeah, no, she likes you.
Sorry, there's one.
Oh, sure, no problem.
She watches every day.
Mhm. Yeah.
And there's more. You're gonna.
Oh,
hate
there's
me.
more?
Two more.
No.
I'm sorry. I'm sorry.
Oh, you know, it's easy. I don't have to date anything. So signature. So that's great.
And give you my birthday. And if I don't see the one.
Oh, Merry Christmas to you. You have a great one.
You too.
All right, thank you. All right, the parties on Jacqueline Kate Wood.
Ms. Wood?
If you come forward. All righty, I'm going to need everyone in the jury box to be quiet because we're going on the record, and everyone else, please whisper. Court is calling 2019 CR 11429W, State of Texas versus Jacqueline Kate Wood. Could I have parties announced for the record for the state?
Catherine Pollard?
Defense.
Michael White for defense.
And are you Miss Wood?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Jacqueline Kate Wood who was placed on deferred adjudication in 2019 CR 11429W for the offense of aggravated assault with a deadly weapon on October 16, 2019 for a period of 4 years? Is that you?
Yes, ma'am, it is.
State?
Judge, it's a violation of condition number 2 on or about the 6th day of December 2021 in Bexar County, Texas. The defendant, Jacqueline K. Wood, did then and there illegally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
The judge will waive the other alleged violations.
Any objections to the state's waivers?
No, yeah.
All right, Ms. Wood, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am, I do understand.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Yes, Judge. We're asking for amend for DDRF and then the MIC caseload upon release.
All right, my understanding, DDRF, that's 32 weeks, so that's not going to happen. So, yes. 48 weeks. All right. So anything that's above 20 weeks, DDRF is out because I can't have someone sitting over at the jail waiting for transfer that long. Talk to your legislatures about that and about funding. I can't do anything about that. So, yes.
4 to 8.
Oh,
Sorry.
somebody has talked to the legislature. Wow, it's only 4 to 8 weeks. So, do you want me to follow that agreement?
Actually, ma'am, I don't feel that DDR would be a place for me, because my mental frame of mind now is way different than what it was when that tappy ball was done earlier in the year.
Are you on medications?
I've been trying to get on my medication since I've been here in jail, and I've been trying to get in with the Center for Healthcare Services to get put back on my medication.
All right, so here's the thing, Ms. Wood. You're on deferred adjudication for an offense that could result in you going to prison for 20 years. Everybody has an idea of what their program should be. Everybody wants to write their own program. I appreciate that. I internalize what you're saying to me. But here's the thing. If we could all write our own programs and we were doing great at it, we wouldn't be here. Like you wouldn't have been using because you would be on your program, your own program, and you would be doing just fine on it. So obviously that's not working. So I'm going to deny the motion. Alter the main conditions to include the MIC evaluation, DDRF, because I see here, I've tried intensive outpatient treatment with you. Usually what I start everyone on is intensive outpatient treatment, and you have been unsuccessful on that. So obviously, this third party needs to write your plan. So that's what we're going to do. And you have children, and you need to start thinking about your children.
May I say something, Your Honor?
Sure, you can, but it's not going to change the fact that you're going to DDRF.
Well, I understand that, Your Honor, but since I've been incarcerated, I've participated in AA meetings. And I've also been acting as trustee within my pod and doing good and positive things. I've also, through CPS, completed outpatient drug counseling back in 2020 with a Dr. Castillo.
All right, but that outpatient treatment didn't work. So you're doing DDRF. You can either do that. If you don't want to do it, you don't have to do it. I can send you to prison.
No, I'd rather not go to prison, ma'am, because I feel that I don't belong there.
All right. Well, you belong at DDRF. Thank you. Court is calling John Ayala. Where are you?
He's coming up, Judge.
Thank you. Hello.
So, TDR,
Yeah, it's a beautiful day.
the
We're not on the record. I'll let you know. If I call the case number, then you know we're on the record. All right, what is happening with this case? The last time we were here, the state was to speak to the complainant.
Yes, Judge, and they did convey an offer.
Okay,
Um, and
and that was done today?
yes,
Is your client prepared to accept it today or no?
not today.
All right, Ms. Ferguson, I need a plea deadline date on Mr. Ayala. 30 days. All right, so we're going to come back on January 17th. On that date, you need to let the court know whether or not you're accepting the state's offer. You understand? After that date, the court will not consider any plea bargaining agreements without good cause. Otherwise, you'll have to plead open to the court. Do you understand? All right, good luck to you, Ms. Ferguson. We'll give you a reset form. Great seeing you. Have a good one.
Always, Judge.
All right, thank you.
Holidays.
Oh, happy holidays.
To wait sometime looking around for Judge.
All right. Happy Festivus. We'll be here next week.
They sure looking for me.
Okay. Who's here on Johnny Tejeda? Oh,
I'm here for the Ada. Or to walk around.
all right, Mr. Tejeda, why were you late?
I do apologize for that, Your Honor, I drive kind of an older vehicle, and I guess this morning the battery with the cold weather, it just didn't want to cooperate, and I had to find a neighbor to kind of give me a jump starter. I do apologize for that.
Okay, all right, you can't be late again, okay?
I fully understand that.
All right. So today is his plea deadline date.
Right.
Yes. So is he,
Who wants a jury trial?
all right. State, how long do you expect the jury trial to last on Mr. Tejeda? It's a failure to stop and render aid, death.
Marcus has been.
I remember reviewing that case with Marcus, it's probably gonna take 4 to 5 days. There's quite a few witnesses.
Okay,
But they're also not gonna consolidate them. They're gonna try them separate. They wanna try them back to back to back.
okay.
I don't know if that's gonna take 4 or 5 days.
All right, we'll see what
Throwing
happens.
that out there.
All right, I appreciate that.
I appreciate that.
Do you have all the discovery? All right, so state, I'm gonna need a discovery acknowledgement in each one of these cases.
Okay, Judge.
And Ms. Ferguson, I need a jury trial date on Mr. Tejeda. They say it's gonna take 4 to 5 days. All right, your jury trial date is gonna be February 7th at 9 a.m., all right? Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you have to apply open to the court. Do you understand?
Yes.
All right, thank you. Thank you.
Thank you, Judge.
All right, who's here on Francisco Reyes? Attorney on Francisco Reyes. All right, and Norma, can you see if you can get in touch with John Robertson? And have him see if he can come over? All right, the attorney on Francisco Reyes. That's okay. All right, no problem. And if you guys could switch. All right, today is his plea deadline date. Is he accepting the state's offer or no?
No, Judge. We'd like to set it for trial.
State, how long do you anticipate this trial taking?
Possibly 2 to 3 days, Judge. There is one discovery issue. I did see, so all we had uploaded in the felony was a police report, but I did see there was a case on the corresponding day. I haven't had a chance yet to check into the other case. I know it was dismissed. But I think the discovery's in there. I just haven't had a chance to check it. I'd like to
Alright.
probably do that this afternoon.
Okay.
I believe there's some form of other discovery issues that we're working with trial.
Ms. Ferguson, on this case, can you call this for the third week in January for discovery?
Yes.
Yes. All right, we're going to come back on January 20th for discovery. Is there anything else?
There's been a motion to modify bond conditions.
Okay,
Staff copy should be in front of you.
have you conferred with the state?
Yes, Judge.
Are you in agreement or for him being allowed to work or no?
Your Honor, no, just because of the fact, so this case, the bond was modified due to the fact that he picked up an assault, bodily injury against the complainant. Back in December, so we're not in agreement.
All right, we can go on the record. All right, everyone, I need you to whisper. Court is calling 2022 CR 8087, State of Texas versus Francisco Reyes. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Jacob Linder from defense.
And are you Mr. Reyes? All right, defense has filed a motion to modify bond conditions of GPS. State, have you had a chance to review the defense's request?
Yes, Your Honor, we have.
All right, are you in agreement?
No, Your Honor.
All right, defense.
Judge, Mr. Reyes has no violations of his house arrest, nor has he had missed court at all. He's always been here and on time in this court. He had no other bond violations. He is on house arrest currently for an alleged assault. We are working on that case as well, working our best to get that case dismissed. Mr. Reyes currently has custody of his children for 2 weeks. And being on house arrest really hinders his ability to care for his children. Also, he's not able to work from home. So not being able to go to work obviously will affect his ability to care for his children. Judge, we'd ask that you either remove the GPS or at least remove the condition to keep him on house arrest.
All right, state.
Judge, the main concern the state has here is that while on bond in this case, he did pick up an ABI married household against the complaining witness in this case. That's why GPS was imposed in the first place. Again, the main concern is that he did violate his bond. He assaulted the person. So that's why we would ask that house arrest remain in place.
All right, before the court makes a ruling on this, I'm going to need to hear from the complainant because that's the reason why the GPS is in effect. And I need to know that they know what's happening here today.
Yes, Judge, we try to have them present today, but they were not able to make it.
All right, just get a date set for Miss Ferguson, and I'll come back and I'll hear that. But it needs to be done no later than the 19th.
Thank you, Judge.
All right. Oh, and excuse me, counsel, Miss Ferguson will give you a reset date form for your client.
Yes, Judge, thank you.
You're welcome. Caroline, could you stop that one? The other one. Move over. Yeah, with the affidavit, it should have been that one. Yeah. You're right. Is it gonna be? That's- You ready on all of this? But have you configured it? Norma, on all the cases where people are filing a motion to withdraw because they're accepting the DA's office or they have a new job. I will set for the 19th, so I need to hear those. Yes, because there, and you can have, I think Jeff Mulliner, Eric Reynolds. Eric Reynolds, some of them. Yeah, just, and we'll see if they come. And Eric may have to do it by Zoom. I think he's in the Bahamas. All right, who's here on Thomas Ollie?
Honor. And I had car trouble this morning. I switched cars. I forgot my jacket.
Okay,
Sorry.
well, I mean, if you're gonna forget your jacket, at least wear purple. So there you go.
I'll take mine off.
Thank you, Judge.
All right, Mr. Thomas Ollie, if you'll come forward.
And Your Honor, we're here to see if he can set his bond. He apparently his bondsman said they lost communication. And he thought he was calling enough. He said he paid the bond in full. But he'd like the court to set another bond. I don't think you can reinstate that one, but he has to set his bond.
So is he only not have a bond because the bondsman got off his bond,
That's my understanding.
Ms. Ferguson?
Yes, there's an application.
All right, so what was his previous bond set at?
Sorry, Judge, I thought that was.
No, it's not.
What was that case number?
Oh, it's this one.
It's all.
But have you conferred with the state on these cases?
I don't think I have, Your Honor, honestly.
All right, so before we take this matter up,
I have a 10-30 juvenile detention hearings. I've got 2 other felonies. His family loves him so much. They're calling us every day.
well, no, I mean, I understand you have
I'm
two
just
other.
worried if I don't make it back.
Well, no, here's the thing. I understand about juvenile detention hearings. I understand that those are considered district courts.
It's with Judge LaBorde, and she's very thorough,
No, I mean, I understand.
and she takes a long time.
Okay, but can you confer with the
Yes,
state?
ma'am.
All right, thank you. All right, just have a seat. Matthew Cole,
Your Honor.
He's on Zoom.
Hmm?
He's on Zoom today. Reporting live from Washington State.
all right. So what is happening with this case?
We got a new offer today. I need to discuss with Mr. Cole. We are moving towards a trial setting, another case, so we'll be accepting or rejecting that offer.
All right, have you talked to him about the offer?
No.
You want to call him on the phone? Mr. Cole, unmute.
Okay, I'm unmuted now.
Oh.
There we
Your attorney's going to call you on the phone
Okay.
and tender the state's offer to you, okay?
go. Okay, sounds good.
All right, so I'm going to put you in the waiting room and your attorney will call you and then we'll come back.
Oh,
Okay, yes, ma'am.
All right, thank you. David Gallegos. You come in and bam, it's here. Where's Mr. Gallegos? Come forward.
Third day in a row.
Okay. All right, what's happening on this case?
Not much, Judge. So the state still hasn't had the opportunity to look into the Brady information that we asked about last setting. False interview with witnesses in the household during. And Mr. Gallegos has picked up 2 new offenses, which I think Norma's in the process of assigning me. One, I believe the state has nothing in discovery other than affidavit for the arrest warrant.
All right, and what are the new cases?
Assault public servant and violation of bond. By assault.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. David Lee Gallegos for discovery?
Yes, the 20th.
All right, we'll come back on January 20th. All right, thank you. Who's here on Daryl Masters? Daryl Masters, the attorney.
I just saw Ron Ross a second ago.
He just walked out a couple minutes ago, Judge.
All right, thank you. Michael Kilgore,
That's him too.
Juan Davila. All right. Mr. Davila, come forward. Good morning. All right. Have you conferred with the state?
I have, Your Honor.
All right. So where are we on this case?
We're new to the district court and Jack is transferred to another district court. It was re-indicted and we're waiting on. Well, we have medical records. We are unable to open up the family, so. Yeah.
All right. State, is this criminal trial division or family violence?
It's not family violence. It's.
All right. So is there a password to the medical records?
Yes, and you're unaware of the date.
All right, state, on this case, my understanding there's medical records. They're gonna need the password.
Yes, I looked on our system and I don't see the password listed anywhere. I was gonna go and talk to.
Okay, so what I'm gonna do is we'll recall this for 30 days for discovery.
Yes.
And hopefully by then you'll get the password. All right, thank you. Ms. Ferguson, can I have a date for discovery on Juan Davila?
I can do the 20th.
All right, we'll come back on January 20th. What page is he on? Thank you. All right, we'll see you then.
Thank you.
You're welcome. Yes. Christopher Island. Hello. And I think I remembered to pronounce your name correctly.
Yes, ma'am. Thank you.
You're welcome. All right, so you filed a motion to withdraw?
On both cases, Judge, he has a third case, Mary Saul. Somebody's pointing that one. He's supposed to be back Monday.
All right, so
He just doesn't have some resources, Judge, and the other case.
Whisper.
Just made more sense to see if the court would be inclined to allow me to withdraw, allow him to have this attorney represent on all cases.
all right, do you have, Mr. Island, do you have any objection to this attorney withdrawing? All right, so Norman, can you make sure Mr. Chumley comes? Right, Chumley?
He said he's gonna be here.
All right, so I'll sign your motion to withdraw, and if you'll just have a seat, we'll wait for your attorney.
You mentioned there, Judge.
Yes.
Should be put into each one of the motions, and I provided him with a copy of everything, along with the listing of all motions and everything else that need to be known, done for him.
And Norman, could you make sure Mr. Chumley is on each of these cases? Thank you.
Judge, may I be excused? Your Honor?
Yes, you're excused.
Thank you, Judge. Good seeing you.
You too.
I stepped out there.
Okay. Who's your client?
I have 2 masters in field work. Masters in MTR.
Okay. All right, if you can sign those. I mean, sorry, file those.
Oh, you filed them. It's because I didn't have a copy of them, so these were his.
Okay.
He filed them.
Okay, awesome. All right, here's this. Cheyenne Fox. Fox. All right, what is happening with Fox?
So, Your Honor, we were originally scheduled for a plea today. Ms. Fox was found not competent back in March. She was extended in July for another 60. And on the eve of that, the expiration of those 60 days, the doctors were going to extend.
Wait,
her.
come on just a second. So attorneys, I try to keep the center of this room not so congested. So if you all will place your file with the state, I promise you, they're going to call you in the order in which you appear. Hovering around their desk is not going to make them call you any faster. So if you all could clear this area, please. And the other reason you need to clear the area is because the deputies need to have eyesight on the inmates, and they can't do it because you're blocking it. You are making better doors than windows, so please move. Yes,
Okay, so the 60-day extension was in July of this year,
yes.
and on the eve of expiration of that, the doctors were going to extend her again. Within a couple of days of that notification, they said, no, she's competent. So she was restored on November 17th. Since then, I've noticed an extreme deterioration in her condition, and I don't believe she's competent at this point. I would like to have her evaluated again.
All right. Ms. Ferguson? All right, we need a reset for a competency evaluation. Yes,
And if I pass it, the competency evaluation, then I can come back to court
yes,
and then we'll handle the case.
yes. Do you understand what you're charged with?
To assault on a public servant, isn't that like a TDC charge?
Well, not necessarily. I mean, there's a range that's associated with you, with it,
What
a
is
range
it?
of punishment. And your attorney can talk to you about that.
He said that the GA was trying to.
No. No, here's the thing. Don't discuss with me what the offer is, okay?
Oh, it's your decision.
Yes. All right, what date?
February 13th, I'm gonna have. February 13th.
All right, counsel, I need you to file that motion today and
Yes,
we'll
sir.
sign it today and refer her.
Miss,
Yes.
is it, competency test going to be on February 13th?
No, that's when you come back here. What they're going to do is, well, the process for competency is that it's going to be sent to Judge Carruthers Court. And then a doctor will come see you. A doctor will speak with you. And then that doctor will file a report. And if they do that quickly before February 23rd, when you come back here, then I'll see you before then.
Oh, so am I gonna do a competency test before the February the 13th?
No, February 23rd.
Oh, so I'm gonna come back and see you on February 13th. Then
Oh, the
after-
13th, sorry.
And then after February the 13th.
You know better than I do.
On February the 23rd, then that's when I'm gonna take the competency test.
No. So I made a mistake. Ms. Ferguson told me that you're coming back here on February 13th.
What for?
Just to see where we are on this case and for me to make sure that everything is being done to help you, okay?
Oh, so, but no matter what, I'm gonna get a competency test done.
Yes. And no matter what, we'll have you here on February 13th so that I can make sure that everybody's doing what they're supposed to be doing.
But do you think how many months do you think it's gonna take for a competency test?
Well, what I'm going to do, usually they have an informal inquiry first. I'm going to ask them to bypass that. And we're just going to go ahead and have a doctor evaluate her without doing that step.
Do you think it'll be like by the end of February?
I'll tell you what, I'll do my best. I'm going to ask them to expedite it, but I don't want to give you a date and then it not be true.
But it could possibly be by the end of.
Yeah, it could
February.
possibly be by then.
But it'll show up on the computer that I'm waiting for a competency test, right?
Yes.
Okay, thank you.
You're so welcome. Do you have any other questions?
No, ma'am.
You've brought joy to my day today. Thank you for being so kind and patient.
Thank you.
All right, bye-bye.
Thank you, Your Honor.
You're welcome. So Ms. Ferguson, on that one, can you just send a motion to Judge Carruthers Court and tell them that she doesn't need a informal inquiry, that I just want a doctor to see her? Yeah. Let me find this on our docket. Just give me one moment. All right, thank you. Yes.
Hi, you ordered Mr. Richard Salas to appear because he had a second violation for not having the ignition interlock on his car.
Yes.
I sent you an email. He's been calling them, they didn't have any. And then last night he got an order. He will have it on by noon today. They finally got one in, so he will have it today by noon.
All right, so if you can do me a favor, just report here today at noon because we'll still be here.
I
And let-
cannot.
No, I mean,
I'll
call.
have him.
call in and let us know if he actually has.
I won't be able to do that. I have surgery at 11:30.
I didn't know you had surgery.
No, I
Yes.
will, yeah.
Yeah,
That's why I
no,
was
tell
like,
him
oh,
to report here then.
oh, after he gets it, well,
Yes.
okay, I'll let him know then.
All right, thank you. Well, and I know surgery is going to go well.
Oh, thank you.
All right, have a
Merry
good one.
Christmas.
Merry Christmas. And thanks for coming in. You should have just called.
Well, I wrote an email, I didn't get an answer from her.
Okay, all right, thank you. Who's here on Daryl Masters? And are you ready to proceed? All right, could I have someone from the state? Okay, you ready? Court is calling 2022 CR 0502, State of Texas versus Daniel Masters. Could I have parties announced for the record for the state?
Michelle Hayden for the state.
Defense? And are you Mr. Masters? All right, I'm gonna need you to speak up so I can hear you, okay? All right, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Daniel Masters, who is placed on deferred adjudication in cause number 2022 CR 0502 for the offense of aggravated assault with a deadly weapon on April 13th, 2022 for a period of 5 years? Is that you? All right, state.
Violated condition number 2, on or about the first day of September 2022 in Bexar County, Texas. The defendant, Daniel Masters, did then and there fail to submit to drug testing as directed by the court/court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 4, in Bexar County, Texas. The defendant, Daniel Masters, did then and there fail to report to the supervision officer as directed for the month of September 2022 in violation of condition number 4.
How do you plead to that? True or not true?
And will waive the remaining violations.
Any objections to the state's waivers?
No objection.
All right, did you understand by pleading true to violations 2 and 4, the court could find it true, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violations 2 and 4? All right, the court will find 2 and 4 true. Is there an agreement?
Yes, Your Honor.
And what is the agreement?
We ask that you find the violations true, that you continue the defendant on community supervision, and that you amend the conditions of probation to include safety special needs.
All right, is that the agreement?
That is the agreement.
All right, Mr. Masters, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. So what is going on? Why are you not doing your drug testing? All right, so I see that he was with Esperanza Court.
Yes, she didn't do that. And he got some mental health problems. Some drug problems too.
All right, so this is what I'm going to do. I'm going to deny the motion. I'm going to alter the main conditions to include a re-referral to Esperanza Court. And we can do Safe P. So if Safe P special needs, so if Esperanza Court doesn't accept you back, then you'll be going to Safe P. Do you understand? All right, here's the thing. You need to open yourself to receiving help, because nobody can help you if you don't want the help. So if there's a reason for you not doing drug testing, if it's going to be that you're going to be positive, you need to own it. If there's a reason for you not doing Esperanza Court because you don't want to face the fact of where you are in life, you need to own it. At the end of the day, where we are currently in life is not where we're going to end up. This is just a journey. And hopefully at each step of the way, we're improving. But we can't improve if we're running from our problems. And guess what? When we run from our problems, what ends up happening is the problem is bigger and it's still there waiting for you at the front door. And you got to go through the front door. There's no back door. Okay. All right. So I'm going to deny the motion, alter and amend conditions for a referral to Esperanza Court. And counsel, if you can contact Esperanza Court, I believe I want to say court coordinator over that is Christine Caceres. And that's out of Judge Stahl's court. If you can talk to them and let them know that he's willing to come back and follow their treatment plan. And I'm going to have him remain in custody until transferred either to safety or acceptance to Esperanza Court. But probation, I want him to be considered for Esperanza Court before safety special needs. You're welcome. Is there anything else you need from the court? All right, you need to communicate and do better, okay? All right, is there anything else? All right, thank you. You're welcome. All right, the next one is Michael Kilgore. Who's here on Michael Kilgore? Okay. All right, so where are we headed on this case?
Judge, this is Michael's first sitting. You had an offer. We were here Wednesday. Michael wanted a couple of days to consider the offer and he decided not to accept the offer. And so right now, it looks like we're going to proceed with trial. I know the state has not been able to contact the complainant and the victim yet. And so they're going to do that. And then it looks like we're going to proceed with trial.
All right, Ms. Bergen, how long do you all expect this trial to last?
A couple days.
All right, and I'm assuming you're proceeding on the aggravated assault first?
Yes, Judge.
All right, Ms. Ferguson, can I have a jury trial date for Mr. Kilgore?
March 14th.
All right, I'm going to make March 14th your plea deadline date and your jury trial date. You will be brought over dressed for trial in whatever civilian clothing you have at the jail. If you would like to be attired in something differently, you'll need to speak to your attorney and you'll have to sign a clothing exchange. Counsel, if there's an issue with the clothing exchange, let the court know and we'll see what we can do to help expedite that. All right, is there anything else? All right, State, if you could do a discovery acknowledgement for counsel.
Yes, sir.
All right, thank you. Who's here on Caleb Coleman? Caleb Coleman. All right, we'll wait for your attorney to show. Ollie Thomas, are you ready? Still conferring? All right, Mr. Thomas, just have a seat. We'll get with you. Have you already done Matthew Cole or no? Who's here for Matthew Cole?
That's Peggy's wife.
Okay.
I think he's looking at-
Oh, he's calling him. Yeah. Kimberly Marsh.
Good morning, Your Honor.
Good morning. All right, the court is calling, and everyone needs to whisper. Court is calling 2018 CR 3998, State of Texas versus Kimberly Michelle Marsh. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense
And was honored child.
and good seeing you. All right, Ms. Marsh, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Kimberly Michelle Marsh who was placed on deferred adjudication in 2018 CR 3998 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on November 15, 2018 for a period of 2 years and extended for a total of 3 years? Is that you? State?
Violated condition number 41 on or about the 25th day of October 2022 in Dare County, Texas. The defendant, Kimberly Michelle Marsh, then and there failed to comply with the rules and regulations of the felony drug court program with continued use of controlled substances, namely cocaine and methamphetamine, in violation of condition number 41.
How do you plead to that? True or not true?
State waives all the violations.
Any objections to the state's waivers?
No objections to the waivers.
All right, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of condition 41 true. Is there an agreement?
No, Your Honor. The agreement is for revocation, but there's no agreement as to.
All right, state, what are you requesting?
State's requesting 1 year in the state jail facility.
Defense, what are you requesting?
Your Honor, we are asking for you to consider the 277 days that she's already served her time, big time served. And to lessen the sentence.
All right, Ms. Marsh, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. So why did you not do well in felony drug court?
Well, in the beginning, I didn't do well, and I went to PDRF, they discharged me with the alcohol, and I got out, and I did really, really well. I had a relapse in May. And then I thought I had done really, really well up until this past October, and I had broke my foot. And in the hospital, they gave me pain medicine, and it kind of sent me down the wrong path.
See, here's the thing, though. I was an attorney in felony drug court, and I know people who are serious about their sobriety, whenever they have injuries or they're going to the hospital, those questions are always asked. And if you tell them, I'm in a drug program, they'll try to find you something that's not an opioid to give you. So did you not tell them?
No. And I should have,
And so
I have been going to my meetings. I have been going to meetings every night. It's just, I failed there.
And here's the thing, the court knows the felony drug court program, and I know they don't kick people out because you use, right? They want you to stop using, they want you to maintain your sobriety. Now, what this sounds like to me is there was continued use and no real effort, because if there were real effort, felony drug court would still have you and they would still be working with you. So the state is asking for 1 year. Your attorneys are asking for you to have 277 days. Either way, because this is a state jail felony, they will probably take you to the state jail facility to be processed, whether I give you 277 days, whether I give you a year. So this is my question for you. What do you think you deserve?
I'd like that sentence, and I'd still like to continue with outpatient certifying outpatient AA and A meetings. I still would like to continue that. I'd still like.
I mean, no, here's the thing. Let me just tell you, if I were to continue you, you're going to somebody's inpatient treatment. It's not going to be on outpatient.
I would like to go to alcohol.
Have you all discussed her trying treatment again or no?
Your Honor, we did discuss that. The state recommended safe.
So it's not going to be Alpha Home for you. That hasn't worked. So it's either going to be Safe P or maybe SATA or maybe ISF, but either way, you're not leaving the courtroom today. Either way, you're not leaving the Bexar County Jail today. So what do you want?
Jail.
All right. And how much time do you think you deserve? This is not what you want. It's like based upon what you've done. Okay. All right, the court will grant the motion and you don't want treatment, correct? All right, when you are released from custody, everything that made you use before is still going to be in the world. And what I can tell you is people who are selling drugs, it's not FDA approved. You may end up with some bad drugs. You may end up ODing, or you may end up getting caught before you use, in which case you're going to have another case.
I plan on continuing outpatient, well, AA and NA when I get out as well. I belong to the lifeguard NA meeting over there on Woodhouse.
Okay. Well, if you want, I can recommend the therapeutic community for you. It doesn't extend the length of time that you're in custody, but I can't force them to accept you. You'll have to ask for it. So would you like that?
What is that?
It's to help you with your drug issues.
Yes.
Okay. All right, the court will grant the motion, find you guilty, sentence you to 1 year in the state jail facility, give you credit for any time served. And the court will request that you be placed in the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorneys? Did you understand it? And did you sign it? All right, this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
I think so. I have one.
Yes.
On the therapeutic community, does that mean I can't go home?
No, what that means is for the remaining of your time, if they accept you in the program, you will be there.
Oh, okay. Yes, ma'am. Absolutely.
No, this is for you. Yes, one for you and one for your client. All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, Ms. Marsh.
Thank you, Your Honor.
You're welcome. Have a good day. Who's here on Gracie Segunda and Mario Pinata?
Give you a file or not? Yeah. You got it?
Hello.
Yes.
If your clients can come forward, have you conferred with the state?
We have.
All right, did you receive an offer?
No, I believe that he was going to reach out to the victim.
So. May I speak? Judge?
Yes.
Okay, so earlier what I spoke about was whether I was going to review it and possibly reduce it down to a misdemeanor.
Okay.
And or proceed as a felony. I told defense that we would not be reducing it at this time to a misdemeanor. We would proceed as a felony.
Whisper.
I noticed in our file that we have communication with the complainant, but it doesn't seem like there's ever been any communication discussed about a potential offer that would be made.
Okay.
So there were some injuries that were pretty substantial injuries that were received by the complainant, and I would like to speak with that complainant prior to making the offer.
All right. Ms. Ferguson, on Segundo and Pineda, if I can have a 30-day reset. All right, we'll come back on January 23rd. Ms. Ferguson will give you a reset form.
Thank you, Your Honor.
You're welcome.
We dismissed?
Yes, after you sign the reset form.
Yes, ma'am.
You guys can have a seat.
Caleb Coleman Lee. Is the attorney here? Hello. All right. You're always dressed appropriately for court. I appreciate that. All right, on Coleman Lee, we were here for discovery. Where are we on that?
Judge, we've tried contacting the complainant numerous times, we have not returned our calls. Or there was a brief period in time where she actually was a defendant in a county court case, but we could not contact her. It does look like the county court case was resolved. So that's something that we're gonna again try to start contacting her again. There's just a point where we couldn't contact her. For a couple weeks.
Well, I mean, but what are we gonna do with this case? Because that's been a while. I mean, are you all proceeding on this case without a complainant?
So we were still gonna proceed. There are other witnesses to this. There were other people who witnessed what happened. At least for my reading of our file.
All right, have you given a offer to them?
I believe so. An offer was previously tendered.
All right, Ms. Ferguson, how long do you expect this trial to last?
That judge, I looked at the case, but I don't know enough about it to give a good answer. I would assume at least a week. but-
Okay. All right, Ms. Ferguson, can I have a jury trial date for Mr. Coleman? Potentially a week.
I think it's February 21st.
All right, your jury trial date, and I'll make it your jury trial date and your plea deadline date, since the state hasn't talked to the complainant and that offer may change.
Judge, we had a.
Excuse me, you all need to have a seat. Yes,
We had a motion that was on file in regard to discovery as well.
okay.
And I don't know if it actually has been accepted, but may I approach it?
Yes.
I have presented it to the prosecution. I think we have an agreement on most issues, with the exception of the medical record. They, the witness has referred to 113 pages of medical records that she has in her possession, which was talking to the investigative officer, as well as another police officer. We've requested those medicals since July, so we are saying that, you know, this should also act as a motion to suppress. But they should not just show up and say, oh, okay, now we have them.
All right, so this is what we're gonna do. Ms. Ferguson, take this off of February 21st. We're gonna set it for January. That's gonna be the final discovery. And state, you need to give the discovery if you have it. If you don't have it, then we go to jury trial, then things will happen appropriately. All right, what date, can you give me the fourth week in January? Is that enough time for everybody?
That should be your honest.
All right, so we're gonna come back on February 3rd for discovery. Is there an issue? Oh, no, end of January. She's giving me February 3rd. I say end of January. Now, if she would have said February 14th, I would have said something different. So are you working? Is there an issue with your being here?
Yes, ma'am.
Oh, what is the issue?
I can't work. Every job that I've had, turned me down. I was a security guard at the airport. I can't go back there. Was a 5-star Uber driver.
Oh, they're not gonna let you do that with this offense.
5-star Uber driver. They took me out of Uber. They took me out of Uber. To my Amazon Summit account. So I have no source of income whatsoever.
I mean, well, here's the thing. There is nothing I can do about that. So, I mean, what appears on your record appears on your record. There's nothing I can do about it. But I don't want your attorney going to trial without discovery. I don't want to set this for jury trial and there's no discovery request. So your attorney is informing the court that there is some discovery that she has not received. So I'm giving the state until February 3rd to have turned over all that discovery. And if state hasn't and we're at jury trial, then the court will will hear appropriate motions.
So then the motion should be heard.
On February 3rd, yes.
Thank you.
All right, you're welcome. So Ms. Ferguson will give you a reset form. Yes, I think so. Who's here on Jacob Glandon? And we're going to go on the record. Everyone needs to stop speaking in the box. We're on the record. Court is calling 2022 CR 11918W, State of Texas versus Jacob Glandon. Excuse me, there's no talking in the box while we're on the record. Could I have parties announced for the record for the state?
Oscar Salinas for the state of Texas.
Defense?
Kirk Ramsey for us. Jacob Land.
Oh, man, I didn't know I got in trouble.
And are you Jacob Glandon?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Received everything on there, Your Honor. There are some items that I viewed at the office of the defendant's office.
There's some items that I'm not able to disclose, Judge.
All right. And the state has filed this motion to seal State's Exhibit number 2. Any objection?
No objection.
And this is State's Exhibit 2, Judge. It contains child pornography.
All right. And states you're offering into evidence State's Exhibit number 2, but asking that it be sealed.
Yes, Judge.
Any objections?
No objection.
All right, then State's Exhibit number 2 is accepted and it will be sealed. Mr. Glandon, I'm showing you what's entitled Waiver of Indictment, Reading of Information and Rights on Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, sir.
Did you understand you have a right to have a grand jury see the evidence in this case and make a decision on whether or not to indict?
Yes, Your Honor.
Did you understand that your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, sir.
Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, if you could date that for me, please. Next, I'm showing you what's entitled Information. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
Yes, sir.
State, are you proceeding on the information as presented?
Yes, sir.
Mr. Glandon, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review this with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of child pornography? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes.
Mr. Glandon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 4 years in the prison. There's a $1,000 fine and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest?
State any evidence?
Yes, Judge. State offered to mark as State's Exhibit 1 as attachments and additionally State's Exhibit 2 under seal.
Any objection?
No objection, Your Honor.
Mr. Glandon, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding to sentencing? Are you asking for a PSI? All right, probation. Is there any sooner date for the PSI other than February 3rd? Because this is not for an application. All right, we're going to see if we can get you a date earlier than February 13th. All right, so just have a seat and we'll get that date.
And there is something that I need to put on the record, I just remembered. There are 2 additional CM cases that are out of the same transaction. The state, of course, would be rejecting those after he sentenced.
All right.
I realized I didn't put them in the plea bargain.
All right, we're still on the record. Do you want to write that in the plea bargain agreement?
Yes.
Any objections, defense? Defense, any objections? Just one moment. Okay, let me just see if, just give me 1 second.
Yes. Right.
All right.
And they're for the same charge.
All right, don't leave here. Everyone, just give me a moment, please. All right, so we're going to come back for sentencing on your case on January 9th. All right, Ms. Ferguson, on Mr. Glandon, we're going to come back on January 9th. Okay. Oh, just give me the sticky. I'll find it. Okay. All right, and Ms. Ferguson, can you give them a reset form for January 9th? Oh, okay, thank you. Here you are. Who's here on Dante McCoy? Come forward. And where is Dante McCoy?
Good morning, Judge.
Good morning. You all need to switch places. What's going on with this case?
Judge, I conferred with the state, it's the first setting, and so we're just asking for a report.
I mean, it's the first setting because he didn't show up on the 13th. Why were you not here? Okay. All right. Have you conferred with the state?
Yes, Your Honor, I have, yes.
Do you have all the discovery?
Well, Judge, I'm not sure, there's about 200 or plus items and I'm just recently on there, so I haven't had a chance to really get into everything, but I have enough to confer with them, but I just want to make sure that I'm not missing something and get into the more. There's several videos and some other things. So.
All right, Ms. Perkins, can I have a 30-day reset on Dante McCoy, please?
24th.
All right, we're going to come back on January 24th for discovery. Ms. Ferguson will give you a reset form, then your excuse.
I appreciate it.
You're welcome. Yes, but it's sealed. Yes. They filed a motion to have it sealed
Oh, okay.
because it's child pornography.
Oh, well, I don't know. I mean, I still think it's.
No. Yes, yes, you do.
Okay.
Yes, I'm sorry, you do, but she'll have to seal it. All right, who's here on Thomas Ollie? All right, we'll wait for your attorney. Okay. All right, as soon as that's done, I'll take it up. That's going to be a plea. Matthew Cole. Fabian Vega. Okay. Norma, on Fabian Vega, just recall this because they have there's an outstanding witness list. So if you can recall this for the first week in January, the second week in January, what date? Okay. line hooks this when it's done. Javier Medina. Where's your attorney? All right, just have a seat. Gloria Rosca. All right, where's your attorney? Oh, sorry. Come forward. All right, what is happening with this case? Today is her plea deadline day.
Morning, Your Honor. We've entered into a pre-trial diversion.
Okay,
We've got the application filled out. We're in the process of trying to get the ancillary documents for letters and those kinds of things. She's got, we talked last night and she just is trying to get those letters back from the people she's requesting them from.
okay.
We're just not in a lot of control of that, but we're trying to get it.
All right, Ms. Ferguson on a Rosca. If I could have a PTD date, please.
February 14th.
All right, we'll see you back on February 14th. Make sure you get that in.
Thank you.
You're welcome. Ms. Ferguson will give you the reset form. LaDonna Worthy. Who's the attorney? All right, come forward. All right, Mr. Cox, I'm shocked at you. I asked her if she was related to, yeah, and she didn't know who that was. I mean, you have, you disappoint me.
I feel responsible.
Yeah,
I'll make sure that.
that's okay. She wasn't the only one who didn't know who James Worth was. So, what is happening with this case, Mr. Cox?
Transcript from tonight. My client just served a copy of the indictment today. So we don't need at least 30 days to get discovery. All those types of.
All right.
Give me 30 days.
All right. So you're gonna have her watch some Lakers?
She'll know.
She will, because I'm highly
She'll know by
disappointed.
showtime the next time.
She will. All right, I remember that. All right. Next thing I know, she'll be saying she don't know who Clyde Drexler is. He knows, Mr.
He's a spur Peter.
All right, Ms. Ferguson, can I have a 30-day reset for LaDonna Worthy?
No, the 23rd.
All right, so we'll be back on January 23rd. Ms. Ferguson will give you a reset form, and that will be a regular reset. You're welcome. Jason Hickman. Who's the attorney on Hickman?
I am. This is Matt.
Yes.
This is something we.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 5 years in prison and up to a $1,500 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement is we're asking the court to find the violation true.
Just one moment, I'm sorry. All right, thanks, Mom. Oh, no, there's no need to apologize. Thanks for calling. Bye-bye. All right, I'm sorry about that, but here's the thing. When your mom calls you, you need to answer. I don't care what you're doing. Even if you're in the middle of heart surgery, you need to put it on pause and talk to your mom. All right, so we're back on the record. You've entered a plea of true. Is there an agreement?
Yes, Your Honor. We ask that you find the violation true, you revoke the defendant's community supervision and amend the underlying sentence to 3 years. In consideration, we're dismissing the new case. Let me get that cross number. CC 694103.
All right, is that the agreement?
That is right.
Mr. Campbell, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. The court will grant the motion. The court will sentence you to 3 years in the prison. Take in consideration County Court Cause number 694103. There's to be no contact with Jesse, Jessie, Santillan, Santillan. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, we can go off the record. Mr. Campbell, good luck to you. In life, you got to follow rules. Do you understand?
I did not handle the original case. Mr. Campbell wanted to be sure that he got started a longer time. Before he was.
Yes, he'll get credit for any time served. All right, you'll get credit for any time that you've been in custody. All right, thank you. All right, who's here on Andres Menchaca? Andres Menchaca. Who's here on Danny Acosta? Thank you. Good morning. Are you ready to proceed, Mr. Coons?
Conferring with Oscar.
Mhm.
And we're gonna ask if we can come back in a couple of days. Because I think we're hinting possibly towards a resolution. Can't promise support that, but that's kind of the direction we're going.
Okay. This is Mr. Acosta. Can we bring this back on Monday?
Or Tuesday. Can we do Tuesday?
Are we able to bring him back on Tuesday?
And if Oscar can't, if we can't come to a resolution, we'll let the court know, so we don't have to wait the court's time on Tuesday.
Oh, there's no wasted time when you're seeing people. Yes,
Oh, no, I just,
okay.
I don't know if you needed me up here also.
Well, it's nice for you to approach. I appreciate that. But you're not, I mean, you're always needed. Of course, everybody is needed, but they're just asking for a reset.
I can text Monday for it, or I can let John know for sure. I don't have that meeting.
I mean, ultimately, we're asking the prosecutor to do some stuff, so that's.
Yeah, I just need to read some of the ones that are sealed. I think one case that's sealed and another burglary, see if I can just make a big global offer to wrap it all up.
So it's the night.
How busy is Monday? Like, is it a busy docket on Monday?
Well, you know, the 187th, we're never busy in here.
I guess it's Tuesday seems to be more lax, right? Or is there nothing? Oh, there's nothing on Tuesday? Oh, no, then I'll just do it Monday. There's nothing on Tuesday, right?
Do you want to do it the following week and not have me see my mom?
Oh.
Is that what you're requesting?
No, I want you to see your mom.
Yeah, we can put it on the 20th.
Well, I didn't want to put anything on if you all were not gonna.
Oh, I'm gonna be here.
Okay. Tuesday. Well, I don't know, are y'all have a Tuesday or you? Oh, you'll be here on Tuesday?
All right, so we're gonna, Norma, do you want to put it on the 20th then? All right, so we'll. 20th. All right, so we'll come back on the 20th at 9 a.m., okay?
Okay, thank you.
You're welcome. Thank you. You're welcome.
I don't know where.
Here we are. All right, who's here? I'm Matthew Cole.
I'm here.
Okay. What is happening with Mr. Cole?
He's just going to go to the corner. It's going to accept the deal.
All right, so if you'll just fill out the paperwork, we'll take care of it.
We're going to need some time to get some more witnesses. It's a silent offer. We'd like to tender some evidence. So.
Oh, well, I mean, it's a silent offer, so what that means is it's gonna be PSI. Yes, so you do the plea and then we'll set it for another day.
Okay, yeah.
All right, thank you. All right, Mr. Coleman, I'm gonna put you in a breakout room. And so that your attorney can go over everything with you. And Mr. Hagee, if you'll make sure that Ms. Ferguson has his reset form. Mr. Cole, I'm going to send you to breakout room number 1. Your attorney will be calling you.
Okay, sounds good.
Gilbert Alcorta. Gilbert Alcorta. Good morning. What's happening with this misdemeanor case?
They made an offer, they want him to complete some of the classes ahead of time before a plea, and
Who is we? I mean, who is they?
the state.
No, I mean. Okay. Which court is this out of?
8.
Who is the judge in 8? Okay.
She's not available today. I got an email that cases will be sent till first week in January.
All right. Daniel. Daniel Escobar. Hi. Hi. My understanding that this case was going to be dismissed, I guess, was this case to be dismissed in exchange for a plea in misdemeanor court?
Okay.
All right, and the misdemeanor prosecutors are saying that he needs to do some class for them or something before they will give him an offer. Can you, I'm going to reset this, but can you make sure you check on that as to what they're,
What's going on?
yes.
Yes, ma'am.
All right. All right, Ms. Ferguson, can we reset this for the second week in the new year? All right, we're going to come back on January 10th. All right, so we're going to recall you for January 10th, and they'll see what's going on. And she'll give you a reset form.
January 10th, Your Honor.
Yes.
I've got to be in Lee County. Can we do it the 9th?
All right, Ms. Ferguson, are we able to set that on January 9th instead of the 10th? On El Corte, could you change that to January 9th in the file? Thank you. Rudy Gutierrez. Oh, I'm just making up names today. Oh, no, it's Rudy Gutierrez Gonzalez.
There you go. That's it.
There we go. Thank you. All right, so today is his plea deadline date. What's happening?
Judge, we're rejecting the plea offer and requesting a jury trial.
And is this criminal trial division?
Yes, sir.
All right, Ms. Ferguson, I need a jury trial date for Rudy Gonzalez. And it's probably going to be 3 days, maybe?
Yeah.
Yes.
Yes. Is that the day after the Super Bowl?
Mhm. Well, people will be happy or not unhappy.
I'll be hungover.
All right, so your jury trial date is going to be February 7th. You'll be brought over dressed in whatever clothing you have at the jail, whatever civilian clothing. If you wish to be attired in something different, you have to speak to your attorney and sign the clothing exchange. Counsel, if there's some issue with the clothing exchange, let the court know.
Okay, Judge. I'll get it close.
All right, thank you. All right, Ms. Ferguson, we're done with Mr. Rudy Gutierrez Gonzalez. Rosalie Morales. Come forward. The last time we were here, you said it was a possible PTD.
Correct, Your Honor, and I've spoken, there we go. Sorry about that, Your Honor. We were looking at that, and I don't think it's gonna work out because of my client's situation. There's a lot. What we are looking at doing, I conferred with the prosecutor. We're looking at cleaning her on her misdemeanor charge. We're just trying to find a charge that's gonna fit with the facts and evidence that we have. And then TICing this felony case.
Yeah, doesn't, based on the notes and the file that I read a little while ago, it looks like we will not be proceeding on the felony case once she pleads to another charge of misdemeanor.
All right, so is that charge in existence now, or is this something?
And Your Honor, it should have a date if you give me a moment to pull up my
Okay.
calendar, I can let you know, but I'm the attorney representing her on her felony case, and I do know that it is set. It looks like it's set for Friday, January 13th of next year. For conference of it.
Okay. All right, Ms. Ferguson. Can we place this on January 17th? And if that's taken care of the 13th, they will already have taken care of it. Is that
Correct.
possible, Ms. Ferguson?
Yeah.
All right, so your court date in here is going to be January 17th.
Thank you, Your Honor.
All right, thank you. And Norma, that's Rosalie Morales. Damone Wyatt and Damone Thomas.
I'm present for both of them.
Yes. All right, if you can come forward.
Good afternoon. Good morning, Judge.
Morning. All right, so we are here for sentencing.
No. we are going to be here for sentencing. We pled, we discussed with you the possibility of him coming back after Christmas for sentencing, and you said yes, but you wanted today's appearance as a good faith effort on his part. So in good faith, he's here, he's been here, his attorney was late, but he was not. And
Okay, just 1 second, because I recall that conversation, but I want to make sure I put it on my docket sheet because I put everything on the docket. Just 1 second. Yes, it is here.
that's directed, so are we.
Okay.
And we'd ask that you'd allow us to come back. I've spoken to the court, I think. I already forgot what day we talked about. I think we looked at January the 17th.
Okay. We can either do, Norma, and it's for sentencing. Yes, sentencing only. So, are we able to do the 17th or no? All right. So we're going to come back on January 17th, okay? At 9 a.m.
Okay, hold on, Judge, if I may, his wife's having surgery on the 18th. I'm sorry. His mother, his baby's mother's having surgery.
She had cancer. She has diagnosed with stage 4 cancer.
Mhm.
She had surgery, so I was just trying to make sure all of that followed.
So here's the thing, at some point.
Yeah.
No. So what date is her surgery?
It's in the middle of January. I don't know the exact date.
All right, so I'm going to keep this for January 17th and then you can,
do this again and if you'd like.
yes, and tell me what the date is.
Yes, sir. Yes, excuse me. Yes, ma'am.
Okay,
Sorry.
all right, now, all right. Ms. Ferguson, you give them a date for January 17th? And excuse me, Mr. Thomas, come forward.
Sorry. I apologize.
No. So here's the issue. How old are you? How old are you? You're too old to have sagging pants. Yeah.
Sorry about that.
All right. So I don't know why when I was growing up, guys would wear pants that were appropriate size. If you're 24 in the waist, your jeans are 24 in the waist. You don't do a 42.
No, I said, see, nowadays they making the jeans real skinny. I don't like that skinny tight jean fit on me.
Oh, if you just do Levi's, but if you're trying to do, in my day, it was Jabot and all of that. If you're trying to do all of that.
Making Jabots no more. You can't find them.
Well, I mean, that's why Levi's are always here. Maybe
That's
you need
what
to
old
change.
people wear, Judge.
Levi's are still great jeans.
Yes.
All right, who's here on Andres Menchaca? Not here. Mike Perez. Mr. Perez, come forward. And we're going to go on the record. We have 2 cases. Are you okay with going on both cases at the same time? All right, thank you. Norma, I can't believe they call Levi's old for old people. I mean, you know what? A classic is a classic. Thank you. I do too. Do they say Chanel is old? We can't do that.
Is classic by definition old?
Maybe it could be, but sometimes things are an instant classic.
I've got Levi's in my phone.
Yeah, thank you. They're telling us we're old now.
I'm not disagreeing.
Yeah. All right. Court is going to call. I need everybody quiet in the box. Court is going to call 2022 CR 10586, 2022 CR 10585, State of Texas versus Mike Christopher Perez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Orlando Castañon.
And are you Mr. Perez?
Yes, Your Honor.
Counsel, in each of the cause numbers, I'm showing you what's entitled acknowledgement of discovery. Have you received all of the discovery in each of these cause numbers?
Yes, I did.
And each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Perez, in each of the cause numbers, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, Your Honor.
And each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State in each of the cause numbers, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Pettis, in each of the cause numbers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate place?
Yes, ma'am.
Did you understand in each cause number you're charged with the offense of aggravated robbery? That's a first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers? Did you understand if the court were to grant your application for deferred adjudication in each of these cause numbers, if for any reason your deferred adjudication were revoked, the court could find you guilty, you wouldn't be eligible for community supervision, but the court could find you guilty and sentence you up to life in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense in each of these cause numbers?
I do, Judge.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to enter into these pleas?
No.
Has anyone promised you anything other than the pleas?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each of the cause numbers, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And each of the cause numbers, the state is asking that your punishment be assessed at 10 years in the prison. They're opposing your application for deferred adjudication. The cause numbers were run concurrently together, and the state will take in consideration 2022 CR 7825. Did you understand that be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
And each of the cause numbers, I'm showing you what's entitled the waiver of repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Then in cause number 2022 CR 10585, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And cause number 2022 CR 10586, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea?
State offers State Exhibit 1 in all attachments.
No, Judge.
Any objections? All right, State, you can have a seat because I know you're working on other things. All right, Mr. Pettis, in each of the cause numbers, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachment in each cause number, the court will find there is sufficient evidence to find you guilty. The Court will defer finding of guilt as you've applied for deferred adjudication. You'll come back on January 19th for sentencing. Is there a request for a TAP evaluation, counsel?
Judge, I don't believe that was written in there, but we would expect that one be done.
All right, state on this, there's going to be a PSI and a TAP evaluation. And probation on this one, PSI and TAP evaluation. All right, thank you. Is there anything else?
Okay.
All right, we'll see you back on January 19th. On January 19th, I'll make a decision on your application based upon the PSI report and any other evidence that's presented to me.
Thank you.
Thank you.
All right, thank you. You too. Who's here on Anthony Villarreal? No, the inmate that I requested back who was Kirk Sherman's attorney, is he here? You can have him brought out whenever you get a chance. All right, what is happening with Anthony Villarreal?
So Judge, we were previously, I was confirming with Marcus Sanders, he's out on maternity leave, so.
He's not coming back. So,
Oh, my apologies. All right.
well, no, he's on paternity leave.
Yes.
But he's also going to be in a new position, so he's not going to be here.
No, I understand.
Okay.
So with that being said, it was a little bit of a, I guess you call it a stopgap. They brought him up to speed on it. They were able to track down some discovery. It's in the file now, which I'm appreciative for. I need to get copies of that. It's a surveillance video, statement he gave, photographs, more surveillance video and some other stuff. It's about 6 DVDs worth of items.
And Your Honor, just to clarify, the DVDs aren't marked, they don't say what's in them, so I have to actually look through and make sure that they are
Yeah.
what we're looking for.
Yeah. So we don't have a plea offer on the case yet. I don't think they're ready to extend ones. Well, I don't want to speak for y'all, but we don't have a plea bargain yet. However, I think if by next time we'll have one, we'll know whether or not we're going to trial or what we need to do on this case.
All right, Mrs. Ferguson, can you call this back for discovery the 4th week in January? He's on bond.
And there was one other issue, Judge. We had filed a motion a while back and I was speaking with Marcus on it. He's on full GPS house arrest. We were hoping to get him permission to go to work. He does have employment lined up. Do you want to tell?
It's a labor on demand, it's attempt to hire. It's on it's basically a 90-day period. I've got to be there for 90 days and then whether they're gonna hire me or not, but it's a attempt to hire.
What kind of work is it?
It's a landscaping company.
Landscaping. Okay, there we go.
I mean, you need a place where you're going to be stationary. I don't accept any of this as true because I haven't received anything.
Like I said, it's a labor hall, but it's a attempt to hire. I couldn't actually get a place where I am stationary, where I'm at one place all day.
What date, Ms. Ferguson? All right, so this is what you can do. I will consider that allowing you to work if you find a place where you're stationary, not moving throughout the city.
Okay.
So once you get that information to your attorney, just represent it.
Excellent. Give me a, I guess just quick, get your copy free. And then is he free to go after this, Your Honor?
Yes.
Thank you. Your Honor. Have a good Christmas and I'll see you.
Oh, thank you. You too. Leo Gonzalez.
Morning, Judge.
Good morning.
Recall from yesterday, I just have a call. It's emotional resonance.
All right. Okay. Could I have a prosecutor? Court is calling 2022 CR 9296, state of Texas versus Leo Gonzalez. Can I have parties announced for the record?
Daniel Escobar for the state of Texas.
Robert Gaona for the defendant.
This hearing was scheduled actually yesterday. It was recalled for today because the defendant was not present. And then the court will note that on November 28th, the defendant was actually late for court and the defendant was admonished. Defense, have you had any contact with your client?
Judge had contact yesterday morning where he informed me that he was at a funeral. I returned text messages to him, letting him know what the court was going to decide. And then I also sent the text messages that he was recalled for today and to be present. There has been no response.
All right, Deputy Laura, was Leo Gonzalez announced?
Yes, he was, Your Honor, he did not answer. He was in the hallway.
All right, State.
Your Honor, state moves for a bond forfeiture and for a warrant to be issued for his arrest.
All right, the court will issue a judge's warrant and remand with the client without bond.
Thank you.
Thank you. I actually remembered that. But if you give me the thing, I'll sign it, but I just issued a judge's warrant. All right, who's your client?
It's a Henderson session, Your Honor. Just wanted to see if we were in line.
Yes, you're in line.
Okay, thank you.
I'm getting there. Okay, thank you. Oh, this is. All right, could I see the parties on Gabriel, Ariana? Morning, Judge. Good morning. How are you doing? Great.
Good morning, Your Honor.
Good morning. All right. Court is calling 2022 CR 9938, State of Texas versus Gabriel Alfonso Ariana. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas. Efrain Torres Jr. for Mr. Gabriel Oriana.
And are you Mr. Oriana? Yes. All right, we have an interpreter here. I'm going to need y'all to be quiet in the box. So we have an deputy, if you could move them to the end. We have an interpreter here. Could you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, and you could state your name for the record and you may lower your hand.
Flavia Valle, license 314.
Counsel, have you been able to communicate with your client in Spanish?
Yes, Your Honor.
And do you speak Spanish fluently?
I do, Your Honor.
Mr. Ariana, all of the documents that I'm going to be reviewing with you are in English. Were you able to review those documents with your attorney in Spanish?
Yes.
All right. Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ariana, did you review a document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the states, we're going with the lesser included offense of driving while intoxicated as class B misdemeanor.
Any objection?
No objection, Your Honor.
Mr. Ariana, did you review a document with your attorney entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of driving while intoxicated as a class B misdemeanor? The range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and
Yes,
was
Your Honor.
legally sane at the time of the offense?
Yes, Your Honor.
Mr. Oriana, has anyone threatened you coerced you, or placed you in fear to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, did you advise your client of the consequences of pleading no contest or guilty in the application of federal immigration law?
I did, Your Honor, and I also got advice from his independent immigration counsel.
Mr. Oriana, did your attorney advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
Yes.
Did the possible consequences include deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes.
And do you understand the immigration consequences of entering a plea in this cause?
Yes.
Counsel, do you believe your client understands the consequences as it relates to his immigration status?
Yes, Your Honor.
All right. Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on driving while intoxicated as a Class B misdemeanor. They're asking that your punishment be assessed at 149 days in the Bexar County Jail, and there are no applications. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit 1 in all attachments.
No objections, Your Honor.
All right. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and did you sign it at all the appropriate places?
Yes.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses against you, and the right to remain silent?
Yes.
Did you understand that the state would not be presenting any live evidence in this case? Evidence will be presented in the form of witnesses' statements and police reports. Did you understand?
Yes.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 in attachments and review the same. All right, everyone, just give me a moment. This is probation. Just 1 second. All right. So you're prepared to proceed with sentencing?
We are there.
All right. All right, the court is finding the defendant guilty. Court will follow your agreement, and the court is sentencing you to 149 days in the Bexar County Jail. And the court sees that he's already satisfied his 40 days driver's license suspension. All right, is there anything else with regards to sentencing?
No good.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you.
Judge, may I just look on the record?
Yes.
Judge, Mr. Oriana is his country of origin is El Salvador. He's not a US resident or a US citizen, Judge. He does have.
I'm sorry.
All right, everyone, please whisper.
Mr. Oriana's country of origin is El Salvador. He's not a US citizen. Nor a
Slow down.
resident.
She's interpreting.
His immigration counsel is Mr. Rudy Castillo. Mr. Castillo has informed them that he will be taking the immigration custody. At that point, they will try to have some type of defense for him to potentially get him a bond judge, but he knows that ultimately he could be deported back to the country of origin of El Salvador. And his situation is still today. And then lastly, Judge, I assume he is going to get credit for the time that he has served.
Yes, he'll receive credit for any time served.
That's all.
All right, thank you.
Thank you.
All right. Just one moment.
Maybe excuse Judge?
There's one more.
Oh, okay.
Arno Leva.
For President Judge.
If I can get back to the church because I have a doctor's appointment at 4:45 today.
Yeah.
I'm trying
you
to
can
get there.
what?
My plea down with
Sure, yeah.
I just can't miss it.
Okay, no problem. He's next.
Okay.
All right, and this doesn't need to be on the record. Where are we on the PTD?
Good morning, Judge. He's been accepted into the program. He's here to, I guess, submit the paperwork that he offers as to when he's gonna meet with them, what his conditions are gonna be. So that's why we're here. He's been accepted into it. So he's just gonna follow up with them regarding when to meet, what conditions. That are part of the program.
All right, Ms. Perkins, can I have a PTD date for Leva?
We can do the 13th.
All right. All right, we'll come back on February 13th. Just get the reset form from Ms. Ferguson.
That's wrong.
Thank you.
Thank you.
You're welcome.
That's where I be excused?
Yes, thank
Okay,
you.
thank you.
Where's Douglas Kapmeyer? Oh, come forward. Bring your client forward.
Yes, ma'am. No, ma'am.
And what is your client's name?
I'm sorry.
Thomas Ollie. Oh, yes, I've called this case several times. Okay,
Sorry, Your Honor, I was in there. No.
okay. All right, we're on the record. Court is calling 2022 CR 2230, State of Texas versus Thomas Ollie. Can I have parties announced for the record for the state? Defense,
Douglas Kapmeyer.
are you Thomas Ollie? Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, ma'am.
Mr. Ollie, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it? Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Court will find that the defendant, the court will find that the state is in compliance with discovery. Next, Mr. Ali, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of assault, choking, strangulation? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison? Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Ollie, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, there's a $1,500 fine. State recommends deferred adjudication. They will take in consideration 2022 CR 10066. There's an affirmative finding of family violence. There's to be no contact with Jacaraya Sims, Jakereya. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the plea? State?
Yes, Judge.
Defense?
Yes, Judge.
Showing you the paragraph entitled waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the plea bargain agreement, the state is asking that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 150 hours community service restitution in the BIPP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
Yes.
State, any evidence?
Yes, Judge. The offer what's been marked as State's Exhibit 1.
No objection.
Mr. Ollie, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witness the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court is finding there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client's grateful for the offer. He's for acceptance.
What is wrong with you? No, why are you choking people?
He would like it for the same. It's,
But no, it's not a misunderstanding when you choke somebody. So here's the thing. I'm going to follow your agreement, but you are not going to have any contact with her. Do you understand? Do you have any children with her? I'm sorry?
No, ma'am.
When's the last time you had employment?
I would, since I came.
So did you have employment during the time this case happened? All right. When you're released, where are you going to be staying?
Stay here for a little while. But
Stay where?
I'm gonna stay here for a little while.
Well, where are you going to be living? Do you have somebody to stay with? Do you have your own place?
Well, yeah, I stay with my cousin for now. If I had to stay down and I had to stay.
Where are you thinking about going back to?
My hometown.
Where's that? All right. How far did you go in school?
Man,
How far did you go in school? Okay. So what are you planning on doing with the rest of your life?
I'm working, so I ain't doing no very emergency.
Do you have any children?
Right.
How many?
3.
Where are they? All right, when's the last time you saw them? What are their ages?
18, 17, 3,
Dates of birth?
February 25th, February 26th, and November 12th.
All right, are there any drug issues with you? All right, do you want to go back to Greenwood, Mississippi?
I would like to.
All right, I'm going to sentence you to 5 years deferred adjudication. There's a $1,500 fine probated. Take in consideration 2022 CR 10066. There's an affirmative finding of family violence. There's to be no contact whatsoever by phone, email, skywriting, or anything with Jakaria Sims, the BIPP course. What county is that in Greenwood? Hmm? I cannot hear a word. Okay. So he's going to be transferred to Greenwood. You said that's Mississippi? Mississippi. There's to be regular reporting by Zoom or in person. 150 hours community service restitution. 40 of those hours be waived if you provide proof of the COVID vaccination. The court is not requiring it. But if you have it, 40 of those hours will be waived. Parenting classes. Once you complete that, the remaining of the hours will be waived. The BIPP course. There's to be regular UAs, field visits, one time per month, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful? All right, we can go off the record. Good luck to you. You need to keep your hands to yourself. You understand?
Any issues?
Yes.
Thank you, Judge.
You're welcome. Bye-bye.
Go ahead.
All right, John Gabriel Gonzalez. Come forward. Mr. Bond, could you speak with Ms. Ferguson for a moment?
Sure.
All right, Mr. Gonzalez, do you wish to have another attorney appointed to you?
Yes, please.
All right, we're going to go on the record. We're going to go on the record in 2022 CR 5348B, State of Texas versus John Gabriel Gonzalez. Mr. Gonzalez, we were here on December 14th, 2022, and there appeared to be some issues with your attorney. Are you requesting another attorney be appointed to represent you other than Mr. Sherman?
Yes, please.
All right, that's going to be granted. Sorry, that goes with that file. All right, your attorney that came up is going to be Mr. Charles Bont. He's right next to you. All right. So, Mr. Bont, this has been reset for January 24th for jury trial, but I know that you're a new attorney on it.
Yes.
So if you all want to have a chance to confer, I think the state has its file down. It's a possession case.
We'll look at it right now.
All right, thank you.
Thank you.
You're welcome.
I can sit down?
Yes, please.
Priscilla Sosa.
Hello, Judge, we're present again.
All right.
I'm present again, I should say.
Okay. All right. Today is the plea deadline date. What's going on?
Oh, it is the plea deadline date.
Yes.
Oh, no. I was gonna ask this court very nicely if I could get it until January 14th. I'll have an answer to them before then. So the issue is that she's a co-defendant to a defendant that is represented by Mr. Bunk. So I'll review those two cases together. Not to disclose too much about the facts of her case, but There are some issues with it that I would like to at least get a little more familiar with, which would include bringing in the officers, and it looks like there was at some level a federal investigation that was
All
going
right, so
on.
who's the co-defendant?
Ruben Rodriguez, is in your file, Judge.
All right, so Norma. All right, so on Ruben Rodriguez. And on Priscilla Sosa, we're gonna call that back on January 14th. Is there any
I'm
objection?
sorry, 12.
12th. They're telling me January 12th, Ms. Ferguson.
I think so, right? Well, we
Yes,
can come back.
well, you guys can be here.
I'm gonna pass.
All right, and Mr. Rodriguez will come back on the 12th as well. Do you need to speak with him?
No, he knows.
All right, so we'll come back on the 12th on each of those cause numbers. Ms. Ferguson will give you a reset form and we'll see you then.
Thank you,
Thank you.
Judge,
Yes.
I brought this up a couple times in the past. My client still has a light monitor. Is there any chance you can take that off?
wanna-
I don't think she's had any violations.
Is she on tracking? What is she on?
No, just right there.
Okay, State, you want to confer over that?
Thank you, Ron.
Who's here? Mike Bellaloo? Malik Bellaloo? Yes.
Come back on Monday, if that's okay, maybe they'll have.
Okay, sure, no problem.
Judge, I appreciate that.
Yes. All right, Ms. Ferguson. Is your client in custody or?
He is in custody.
They want to have him recalled for Monday or Tuesday. David's out.
I'd rather do Monday. I'm gonna be emailing the prosecutors and maybe we can get something worked out and then let you know. Thank
All
you.
right, so we'll put it on Monday.
Monday, thank you.
You're welcome. Let David know Mom and I are still sending our prayers.
Oh, I appreciate that. Thank you.
You're welcome.
Okay.
Who's here on Andres Manchaca? And you're ready?
We're ready, Your Honor. Also, I turned in a Henderson session about an hour before Mr. Menchaca. I don't know if you have this, a Henderson session. Turned in much earlier than Mr. Menchaca.
I have a file on sessions.
I did, it was off docket.
It's set for today. It's on the docket.
Oh, wait a minute. If it's off docket, no, this is DeLeon. Because I'm taking up the cases that are on docket before I do off docket.
And it's on the docket, Your Honor. I said it.
It did.
It's Mr. Henderson.
Oh, okay. All right, thank you. I'll take care of that. All right, the court is calling 2020 CR 3565, State of Texas versus Andres Menchaca. Could I have parties announced for the record for the state?
Whisper, Oscar Solution, State Texas.
Defense?
Your Honor, Jeffrey Martinez.
And are you Mr. Menchaca? Show you what's entitled motion to revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Andres Menchaca who was placed on community supervision in 2020 CR 3565 for the offense of theft, 30,000 to 150,000 vehicle on October 13, 2020 for a term of 4 years? Is that you? State?
Yes, Judge. Violated condition number 5 in Bexar County, Texas. The defendant Andres Menchaca did then and there fail to report to the supervision officer as directed for the months of August, September, and October 2021 in violation of condition number 5.
How do you plead to that? True or not true? State?
Yeah. Yes, and additionally, in the supplemental motion, there's a violated condition number 5 in Bexar County, Texas. The defendant Andres Menchaca did then and there fail to report to the supervision officer for the months of November and December.
Counsel, before you finish reading, the court doesn't have a supplemental motion.
Was one not filed or? is there-
It's not in the file. All right, thank you. Let me see it. Oh, just fine.
There are 2 additional number 5s.
All right, Mr. Menchaca, I'm showing you what's entitled state's motion to supplement pending motion to revoke probation. Did you review that with your attorney and did you understand it? All right, state, you may proceed with the supplemental.
Thanks, Judge. Violated condition number 5 in Bexar County, Texas. The defendant Andres Menchaca did then and there fail to report to the supervision officer as directed for the months of November and December 2021 in violation of condition number 5.
How do you plead to that? True or not true? True or not true?
And
All
then
right, state.
violated condition number 5 in Bexar County, Texas. The defendant Andres Menchaca did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, and October 2022 in violation of condition number 5.
How do you plead to that? True or not true?
And the state will waive and abandon the remaining allegations.
Any objections to the state's waivers?
No.
Did you understand by pleading true to violations 5, 5, and 5, the court could find it true, grant the motion, sentence you to 4 years in prison and a $1,000 fine? Did you understand?
Yes.
Knowing that, do you still wish to plead true to 5, 5, and 5?
Yes, ma'am.
The court will find 5, 5, and 5 true. Is there an agreement?
No, Judge, there's not.
All right, state, what are you requesting?
The state is requesting that the court grant the motion, revoke his community supervision, amend the judgment for a term of 3 years.
All right, defense, what are you requesting?
Your Honor, in the probation recommendations is for a drug court recommendation. We'd ask the court to follow the probation recommendation for drug court. He tested positive, was the reason for this motion to revoke, Your Honor. He has a substance abuse problem. He would like help with that. He has 2 years remaining on his probation. In lieu, if he does not qualify for drug court, the probation requirement was to go to SATA. He very much wants help and to remain on probation. He has gotten, in the last year where he's not reported, he has been working, gotten his life together, but he needs the help. I asked not to go to TVC today, but to receive the help that probation's recommending that he get.
But why hasn't he reported?
Honestly, Your Honor, he had no excuse. It just, it was scared to happen this day, so there's no excuse for him not reporting.
All right, court will deny the motion, alter and amend conditions. Does your client have any health issues?
No.
No, he does not.
All right, I'm gonna extend him for 2 years. And he's either gonna do SATA or ISF, substantive and cognitive track, whichever one is quickest.
Yes, sir.
Is there anything else with regards to sentencing from either side? All right, thank you. Do better. And counsel, here's your,
Bill formula.
yes.
Thank you, John.
You're welcome.
Oh, for the, this is simple.
Who's here on Island? Are you ready? All right, counsel, his attorney withdrew on the other
Yes.
cases?
And you appointed me on the other two?
Yes.
Great.
All right, so where are we on his cases?
We have a plea on a theft case
they take into consideration, endangering and the assault actually is being taken into consideration.
All right. We're going to go on the record. If everyone can be quiet in the box, the court is calling 2020 CR 10445, State of Texas versus Christopher Island. Can I have parties announced for the record for the state? Defense?
White Chumley for the.
All right, and you're Mr. Island?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Island, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I believe we're waiving count 2, proceeding on count 1.
That is correct.
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with offense of theft, 2,500 to 30,000 of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor. Oh, sorry.
Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than a plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am. Very
Are
much.
you a U.S. citizen?
Yes, ma'am.
He's very much satisfied with you.
Thank you, Mr. Island. Yes, sir.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the waiver of appeal paragraph, I'm sorry, showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 1. Punishment is to be assessed at 15 months in the state jail facility. There's a $1,500 fine. State will take in consideration 2020 CR 4630, 2021 CR 4085, and there's restitution, if any, and cause number 2020 CR 10445, which is this cause number. Did you understand that to be the plea?
Yes, ma'am, I did.
Defense is at the plea?
Yes.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I did.
Court will find that defendant, I'm sorry, just 1 second. Okay, then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Judge, we'd offer what's been marked as State's Exhibit 1.
No objection.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right, the court will follow your agreement, sentence you to 15 months in the state jail facility, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. Take in consideration 2020 CR 4630, 2021 CR 4085, and restitution, if any, in 2020 CR 10445. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. We can go off the record. Here's the thing. You got to change your ways. Otherwise, you're going to find yourself living in the prison or living at the Bexar County Jail or somebody else's jail. Do you understand?
Yes, ma'am, I do.
All right, do better. Good luck to you.
Thank you, ma'am. Merry Christmas.
All right, Merry Christmas to you too. Caroline. Who's here on Crystal Cherry?
Present, Judge.
All right, what is happening on this case?
Judge, this was recalled from Wednesday. The court asked the state to reach out to the witness in this matter. It's my understanding that the state did reach out to the witness, did speak with this witness. But it appears to me, I have to confirm with the state that there's an additional piece of evidence that they have not. The state has not been given.
Mhm.
And so,
And here I could explain further. So
Yes.
Judge, whenever I spoke, it was someone who worked at the hospital in a security capacity. I asked if any report had been written in regard to this for their internal documents. He indicated that there had been one, that he didn't have the authority to release it, and that person did have the authority to be in on Monday. I also don't know if I'm gonna have to subpoena these records, because technically it is a hospital file.
Yeah, you probably need to subpoena the records.
That's what I'm assuming, but I'm just gonna talk to the lieutenant, the person above him, just to see.
All right. Ms. Ferguson, on Crystal Cherry, can we reset this in January for discovery? And it's with hospital records, so if we could do it in 45 days. If it's back sooner, Ms. Cherry, we'll have you back sooner. And state and defense, just let me know if it's back sooner.
yes, Your Honor.
45 days. All right, we'll come back on January 30th.
Thank you, Judge.
You're welcome. Yes, hospital records, and it's Crystal Cherry. Who's here on Carlos Romero?
What is that?
All right. So have you all been able to reach agreement or no?
No agreement, Judge.
Okay.
We tried.
All right, so we're back on the record from yesterday in cause number 2021 CR 5583, State of Texas versus Carlos Romero. Can I have parties re-announced for the state
Officer Smith,
defense?
Cornelius Cox.
All right, and so the court allowed this to be reopened. State, do you have any evidence?
Yeah, State's Exhibit 1. May I?
Any objection?
Actual preview of it.
Oh, do you all want to step back so you can review it?
I had a copy in here earlier, and I don't know where it went, so I'm reprinting it.
All right, if you can give a copy to defense counsel. And Mr. Romero, if you'll just take a seat, but we'll take care of your matter today. Donald Gilliland.
I put in file, I'm still confirming.
Okay. John Gabriel Gonzalez. Conferring.
We're confirming. Yes.
Okay.
We're actually confirming right now.
All right, Francisco Aguilar.
Okay, it's good, she said. Hold on.
Oh, you need to go in a breakout room. All right, thank you. Mr. Cole. I'm going to send you to breakout room number 2 so you can be sworn in by the clerk.
Okay.
Thank you. Oh, Norma, did you need to speak to me about? Okay. So on Francisco Aguilar, we were here because the state needed to speak with their complaining witness.
As I understand, well, at the state.
Okay.
Judge, so.
Yes.
In preparation to speak with the complaining witness, there were numerous videos that he gave an interview. So I had to review all of that, and there were other witnesses to the crime that the state has not gotten a chance to interview because we had to look into what they said previously.
Okay.
In order to verify what they were saying currently. So that's something that we haven't had a chance to do this year.
All right, Ms. Ferguson on Aguilar, if I can have a 30-day reset, please. All right, we'll come back on January 26th to see where we are, and that'll be at 9 a.m. And before you leave, just get a reset form for Ms. Ferguson.
Manuel Rodriguez, Lee's been texting me about that. I was trying to find out what his current bond conditions were. It looks like they changed.
Okay, who is it?
Manuel Rodriguez. Maybe.
Oh,
Yeah, but
this-
I didn't see it in there.
Okay.
But I know they've changed a few times. These are done.
Yes, those are done. I think the only changes that have been made is he's been allowed to go to certain places or do certain things.
Okay.
Because this, yeah, I think that's the only changes where he's been allowed to travel.
So other than that, he's, I saw like something about a curfew in there on Sunday. I haven't.
All right, let me
dealt
see.
with this case a whole lot. So. But I was looking at the JD notes.
Okay. I know if I gave him a curfew, his curfew is, curfew. Only exception is work,
Yeah.
if I gave him one. But I don't see.
Yeah, I don't see it either.
Yeah, I don't see a curfew in here.
Yeah, it was just on JD notes, so.
Mhm.
Jerry?
So let me know if you, do you still need this?
I don't need it. I mean, I just don't think I'm comfortable with these things. So keep texting. I don't know if he's around or.
Well, tell her she'll have to stop by. All right. So the state has no objection?
No, that's what. Mr. Patterson.
Hi, hello, so Mr. Featherston. All right, so with regards to the $700, that's not something where they've done something with asset forfeiture or anything?
We haven't met any of the requirements of chapter 59. And there's no filing on the civil side for.
Okay. And if you could have them sign this?
I will do that.
All right, thank you.
Thank you for the court's time.
All right, you're welcome. Who's down? Rosalie Morales? Okay, so what have you discovered?
So what I discovered was, Rosalie got her reset and she was excused by this court and she went ahead and left. She went to the report to pretrial services and they said that they discovered she has a no contact order with her husband that she was previously unaware of. So she asked me if I could approach the court to change it to a no harmful and injurious contact. But because I'm having trouble getting to my office, getting in contact with my office, we can't file a motion right now.
All right.
So I
So-
wanted to see if we can do it orally, and that's why I had them print out the B page.
Yeah, I can't do it orally,
Okay.
but if you want to bring it back, since your client is on bond, just bring it whenever you want to bring it back, but it needs to be brought back no later than the 20th.
Of this month. Like,
Yes.
yeah, so I'm trying to talk to the prosecutor to see what it is that we can do, but,
Okay.
so you need the interruption.
Yes.
Okay.
All right, Alejandro Espina.
That's fine, Judge, it's a PTD compliance. And just informed me earlier today that he'd spoken with the pre-trial, so I'm just expecting them to get with the state and get us off their docket.
All right.
Hello, Judge, I'm here.
Hello. Can I get a PTD date for Alejandro Espina?
I can do February 13th.
All right, February 13th. If all things are worked out, then he won't have to appear, but otherwise he can appear by Zoom.
Very good, thank you, Judge. May I have an excuse?
Yes, you may be excused.
Happy holidays if I don't. see
Oh, happy holidays to you too. Happy Festivus, Merry Christmas, Happy New Year, Happy Hanukkah, and all under above. All right, thank you.
Thank you, Judge.
You're welcome. All right, who's here? Mariah Lopez.
Yeah, if we have one more pre-trial, I think we're gonna be able to work it out.
All right, so do you have all the discovery?
I believe I do, yes.
All right, is the second week in January enough time?
I think so.
All right, Ms. Ferguson, on Mariah Lopez, can you recall this for the second week in January? They said it's for disposition.
Judge, I have a question. Can I ask you?
Yes.
I'm not on bond right now for that.
All right, could everyone please
Miss
whisper?
Bird.
Yes.
I'm not on bond right now for aggravated kidnapping charge. And so I also had court on the 6th. I didn't show up because I was in custody. My bail bondsman had been contacted like with the family and let them know that the reason why I now have a no bond on the aggravated kidnapping is because I was in court before.
Mhm.
Is there a way I can get a bond?
You have to speak to your attorney. Ms. Ferguson, can I have a date, second week in January?
I can do January 9th.
All right, we'll come back on January 9th for disposition. Right.
No, not right.
All right, Jose Gonzalez,
Morning, Judge. Present.
come forward.
Should be in the file. Yes.
All right, what is happening on this case? Today is the plea deadline date.
It is, Judge. We've been conferring with the state. I conferred with Mr. Salinas this morning. I think he's trying to get up to speed on the file. But I don't know what the state wants.
What, are they changing their offer? Is their offer going to be the same?
I don't know, Judge. Oh.
Hi, this is Jose Gonzalez.
Yes. Reminder.
Today is the plea deadline date.
Oh, yes, yes. Yes, and so my understanding is that he had been speaking with Marcus and Groomer. Obviously, Marcus and Groomer are here. I had known nothing about this murder case. So if we could please, if the court would allow us to extend that plea deadline so that whether, I don't know who the first chair or second chair will be assigned to this course. So that they could review it and give them an offer.
You know, I think second chairs and third chairs, everybody has their law license and.
No, I know, and I understand that, and I mean, it's a matter of, I wouldn't be able to review a murder case this morning and give them an offer before the deadline expires.
All right, Ms. Ferguson. On Mr. Gonzalez, I need a jury trial date and a plea deadline date. And it's a murder case. How long are you expecting this to go? Well, how many witnesses are you expecting? I mean, of course, we need the ME. We need, I guess, a detective is coming in, some police officers, some lay people. No, about a week.
Yeah.
Okay. All right. The earliest we can get to you is April 4th at 9 a.m. On that day, you need to let the court know whether or not you're accepting the plea or not. If you do not accept the plea, then you're going to be going to jury trial on April 4th. After that time, the court will not consider any plea bargaining agreements without good cause. Otherwise, you have to plea open to the court. You will be brought over dressed in whatever civilian clothing you have at the jail. If you wish to appear in a different attire, you have to make arrangements with your attorney through a clothing exchange. Do you understand? Counsel, if there's any issue with the clothing exchange, let the court know.
Yes, Your Honor.
All right, thank you.
Be excused, Your Honor.
Yes. Deputies, Jose Gonzalez can go back.
Excuse me, sir. The file for Joe Gonzalez.
Yes,
I'd like to contact Monday for a plea on that, if you'd allow us.
yes.
Maybe
Ms. Hart,
Yeah, we'll work it out.
all right, can you do it today? Because Monday is sort of a little dicey because we have a limited number of people we're allowed to call back.
Quickly, I can't.
All right, if you get the paperwork done, we'll do it.
Okay, I'll get on it. Oscar.
Who's here? Matthew Cole.
Here, Your Honor.
All right, we're going to go on the record. Everyone, make sure that you whisper. Court is calling 2019 CR 7044A, State of Texas versus Matthew Benjamin Cole. Can I have parties announced for the record for the state?
Catherine Pollard,
Defense.
Awesome.
And are you Mr. Cole?
Yes, ma'am.
All right, Mr. Cole is by Zoom. Any objections from the state?
no judge.
Any objections from the defense?
No judge.
All right, Mr. Cole, you understand you have a right to appear in person for this hearing. Do you understand?
Yes, ma'am.
And are you requesting to appear by Zoom?
Yes, I am.
All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yeah.
Court will find that the state is in compliance with discovery. Is there an application on this case?
There will be one, yes, Your Honor. Yeah. I can't sign it with him because we don't have an electronic version.
Ah,
So we'll have to wait until the PSI for that.
all right, thank you. Mr. Cole, are you applying, is he applying for deferred adjudication or regular probation?
We're gonna apply for both, Your Honor.
All right, Mr. Cole, my understanding you're applying for a deferred adjudication and community supervision. Is that correct?
Yes, ma'am.
All right, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding solely on count 1, waiving count 2.
Any objection?
No objection.
All right, Mr. Cole, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation with intent to commit a felony force? That's the first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court doesn't follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Cole, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count one, asking that your punishment be 6 years. There's a $1,500 fine. They're remaining silent on your application. There's an affirmative finding of family violence, no contact with Alyssa Garcia and Dalton DeWinney. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you
Yes.
understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense and count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Judge, we'd offer what's been marked as State's Exhibit 1.
Yes.
All right, Mr. Cole, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We'll be back on February 13th at 9 a.m. for sentencing. You'll need to make sure that you are in court in Bexar County. The courtroom is located at 300 De La Rosa. Do you understand?
Yes, ma'am.
All right, probation. This is going to be a PSI and a TAP evaluation. And I will send you to a breakout room, Mr. Cole, breakout room number 1. And probation will let you know what needs to be done.
Okay, thank you.
And defense, if you would like to be in a breakout room with them, you can.
Okay, and that's February 13th, Your Honor.
Yes.
I believe our family violence cases are done and we're taking Catherine to lunch for her last day in this court.
Oh.
May you be excused?
Oh, this is Catherine's last day.
Yeah.
Oh,
Unfortunately.
happy trails to you.
Well, she's going to intake. Not her
Oh,
choice, but
and I would say happy trails to you two. We'll meet again, but nobody has seen that Western series with Dale Evans and Roy Rogers. I guess I'm aging myself. Who's here on Gilliland?
We're still conferring.
Okay, thank you. This is gonna be a treat. Manuel Rodriguez.
Judge Stormer was recalling that one from Monday.
Okay.
We've already. And it's gonna be a hearing, we can agree.
Okay. Frank Garcia.
Yeah, we'll do six over six, probably.
No. This is what I just received.
Yeah, I guess we're like, we did a lot.
From Judge Hunt. Something's available to help us out. And this is another.
He's got one.
Hello, Michelle, can you come for a second? Or you can come around the side. Oh, just around the side. And tell her we would love to be there, but we ain't. See, I'm looking out for everybody. All right, we're gonna go on the record. Court is calling 2022 CR 6110, State of Texas versus Frank Garcia. Can I have parties announced for the record for the state?
Oscar Salinas for State Texas.
Defense?
Albert Chidas, Your Honor.
And are you Frank Anthony Garcia?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We're waiting to bend in the enhancement allegation.
Any objections?
No objection.
Proceeding only on count 2, right? Or is this, are we doing the felon possession, right? Sorry.
Yes, felony
That's right.
possession. That's
It
okay.
changed in between, yes.
You all have been multitasking. I appreciate that. All right, Mr. Any objection?
No objection, Your Honor.
Mr. Garcia, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
No, I did.
Did you understand you're charged with felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if you have a plea bargain agreement, the court doesn't have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, your punishment is to be assessed at 9 years in the prison. There are no applications. The state will take in consideration 2022 CR 6111. Did you understand that to be the plea?
Yes, ma'am.
Defense? Defense,
Yes, Your Honor.
state. I always do that sometimes. Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No
State any evidence.
Yes, Judge, state offers with marked as State's Exhibit 1 and its attachments and 7.
No objection, Your
All
Honor.
right, and state, if you give me the dismissal form, you can take a seat. I understand you all are doing other cases. Mr. Garcia,
Daniel's doing it on
Okay.
Adobe right now.
Mr. Garcia, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, just that he understands what he owes the state and prepared to do what he needs to do and hopes that he's not back here again.
All right, Mr. Garcia, I'm going to sentence you to 9 years in the prison. Take in consideration 2022 CR 6111 and give you credit for any time served. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Garcia, how old are you?
35, 18 this month.
All right, so you've been living a hard life
Yeah.
because you're in and out of prison, in and out of jail. Don't be the person that when somebody comes to prison, they say, how's this place run? And they say, oh, ask the oldest person here. Ask Grandpa Frank or Grandpa Garcia. Don't be that person. You're going to have to change your life because at some point in time, you may be before a judge. It may not be me. You may not have this defense attorney. You may not have this prosecutor. And if you come back, your minimum is going to end up being 25 years in prison. So if you have a drug or alcohol problem, there are plenty of places that can help you. If there are other issues, there are plenty of places to help you. You understand? All right, good luck to you. You're welcome. You have the dismissal? Oh, you did it by Adobe? Okay. Defense, they sent it to me by Adobe sign. So let me sign that for you and I'll get it to you.
Daniel's high tech, I guess.
Oh, he is. Oh, wow. It's here. And Daniel, you dated it too.
I think they did it automatically.
Okay, take credit for it. Who's here? Nathaniel Mackey? And this is no application. Court is calling 2022 CR 7546 State of Texas versus Nathaniel Mackey. Can our parties announce for the record for the state? Defense? All right, do you have any objection to this attorney standing in for Mr. Kuntz? All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mackey, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Mackey,
We're making a state jail, right? So what are
waiving
we-
the habitual? Any objection?
No, that's my understanding that it would be waived.
All right, Mr. Mackey, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand, you're charged with the offense of theft under $2,500 enhanced as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court doesn't follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Mackey, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There are no applications. The state will take in consideration 2022 CR 7363. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Your Honor, that's our understanding of the plea. We'd also just ask that he get credit for all the time he served and if the court could consider him for 80-20 time.
Yes. All right, say is that the plea?
Yes, sir.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense is charged. How do you plead? Guilty, not guilty, no contest.
No conflict.
All right. Any evidence to support the plea?
Yes, sir. State officers in Marcus State's Exhibit 1 in its attachments.
All right. It's sort of like things are happening offside,
Yeah.
but we appreciate the things that are happening outside the view. All right, Mr. Mackey, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Today's his 52nd birthday.
No, well, happy birth month.
Yeah.
All right, this is what the court is going to do. The court is going to follow your agreement, sentence you to 2 years in the state jail facility, give you credit for any time served, take in consideration 2022 CR 7363. And as far as good time credit, I do consider those. I do receive those. And if you're doing well and applying yourself, then the court normally gives credit for that.
Yes, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you need to speak to an attorney, okay?
Yes, ma'am.
All right, we can go off the record. You're gonna have to stop stealing. Otherwise, you're gonna find yourself back and forth in here. And I don't think, I could be wrong. I don't know if the Dollar General has food. Does the Dollar General, oh, they do carry food.
Yes, ma'am.
I don't think it's $1 anymore. Am I wrong on that?
No, you know.
All right. So if there's an issue where maybe you need food, there are so many different places for that. But if there's an issue where you just have this compulsion to steal, you better start with that compulsion, because otherwise You're gonna be the grandpa at the prison or the grandpa at the state jail facility, okay?
Yes, ma'am.
And you're gonna be spending a lot of birthdays in prison. Don't let that be you, okay?
Okay.
I've already signed the dismissal by Adobe.
Oh,
Thank
thank you.
you.
You're welcome. All right, who's here on John Gonzalez? Merry Christmas, you too. You have a good one and happy Festivus. I signed it by Adobe. You can see if they can give it to you. Court is calling 2022 CR 5348B, State of Texas versus John Gabriel Gonzalez. Can I have parties announced for the record for the state?
Oscar Salinas.
Defense?
Charles Bond.
And are you Mr. John Gabriel Gonzalez?
Yes, ma'am.
All right, Mr. Gonzalez, at your request, the attorney Kirk Sherman was removed from representing you. So Mr. Bonk was appointed today. Your attorney has 10 days to prepare for trial. Do you wish to proceed?
Where do we go today?
Yes.
All right, and defense, have you had ample time to review everything with your client?
Yes, I have.
All right, and Mr. Gonzalez, I want to apologize to you on behalf of your previous attorney.
Thank you, ma'am. I appreciate it.
Because I do require that everybody treat everybody with respect. I don't care what you're charged with. I don't care who you are. I like to run a courtroom where everybody is respectful to each other. Even if you don't respect them, fake it. You know what I mean? All right, so I apologize for that. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I received it in court today and we reviewed it in court as well. Yes.
Mr. Gonzalez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
No, Judge, state will proceed on lesser included offense of possession of controlled substance less than 1 gram of state felony.
No objection.
All right, Mr. Gonzalez, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, I did.
Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am. I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yeah.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, ma'am.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, today I have it.
All right.
Good answer.
Are you a U.S. citizen?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at 90 days in the Bexar County Jail under 1244. Did you understand that to be the plea bargain agreement?
Yes, I did.
And they're also asking for restitution for the laboratory report. I don't,
I may have done that out of habit, Judge.
all right, any objection to
No,
removing that?
No, please.
Okay. All right, did you understand that to be the plea?
Yes, ma'am. I did.
Defense?
I do it. It's my understanding his judgment will be satisfied. He does have the 90 days.
All right, state?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motion?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence?
Yes, Judge, state admits what's been marked as State's Exhibit 1 and its attachments and separate.
No objections.
Mr. Gonzalez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
I believe before the plea bargain, we ask you to follow it.
All right, the court is finding you guilty. The court will sentence you to 90 days in the Bexar County Jail under 1244. Give you credit for any time served, and the court will show that the judgment is satisfied. Anything else with regards to sentencing?
No, Your Honor.
Mr. Gonzalez, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. You're gonna have to make better choices, better friends. All right, good luck to you. Thank you, Mr. Bond.
Thank you, Judge.
What are we doing with Donald Gilliland?
It's gonna be a plea. We're going to pick one.
All right, thank you. And then Carlos Romero.
Officer Cox.
Okay.
You might be in his office.
Okay.
Right there.
Yes,
That's his office, the waiting area.
yes. All right, anybody else? If you're ready, you need to have your file pulled. Because otherwise, we're going to assume you're not ready, and the deputies at a certain point in time, they're going to start sending people back. But Mr. Romero, don't worry, we will take care of your matter today. Gilliland, that's going to be a plea.
And Your Honor, we're turning the plea right now.
Okay.
Did Valerie something?
Who?
Valerie?
No. Okay.
Mr. Featherston, are you here on that case?
Officer and I are still recording.
Oh, and Oscar, if you and Daniel could look over this, this is going to be set for a hearing, but oh, and this is a part of it. Caroline, I was able to get some food for us, so it's in the back. I do have food for us in the back. And we're gonna have to take care of these cases before my mom calls and accuses me of violating labor laws.
Oh.
All right, Cornelius, I like having you in here because no one here knew where Happy Trails came from until we meet again. I remember you had the entire set, well, you had the entire set of Paladin. Nobody knows what we're talking about. Maybe Charles Blunt has heard of Paladin.
Maybe Charles.
I'll object to that, Judge.
Yes, but have you heard of Paladin? Yeah, and see, I only mentioned Charles Blunt, not due to age, but Charles Blunt is a Renaissance man. So he usually knows everything.
Based on wisdom. That's right.
Through experience and,
Well, everybody knows Paladin, and he wore Levi's too.
he did. That is so true.
Good segue. That was a full 360. Right
It was. We're coming back around. All right, so we're here on the application for bond. Mr. Romero, if you'll come down. And we're back on the record in 2021 CR 5583. State of Texas versus Carlos Romero. And I believe that the state was allowed to reopen their case. And state, do you have any evidence?
Yes, Judge, State's Exhibit 1 and its attachments, and I flipped to the conclusion portion just to make that easier for you.
Any objection?
No objection for the purpose of the hearing.
All right, and is there any other evidence that's being submitted to the court other than State Exhibit number 1?
From the state, no, Judge.
Oh, yeah.
All right, so if you'll all just give me a moment to review, just 1 second.
Yeah.
Yes. Yes. Okay, and Suzanne Kramer says she know about Happy Trails. Excuse me, and here's the exhibit for you. Thank you. And you do have the exhibit from the other case?
No, I didn't.
All right. Did you get her the exhibit from Landon? Okay. All right.
Oh, so.
Yeah. All right, that's a different case.
Okay.
And that's to be sealed. Okay, thank you. All right, after this, after Mr. Romero, guys, we're gonna do next is Carlos Martinez. And that's no application. And then Norma Calvin Rangel. We'll bring it back on the 20th. All right. So we're back on the record in State of Texas versus Carlos Ramirez. The court has reviewed State's Exhibits 1 and the court remembers previous evidence that has been submitted. The court will hear argument, and I believe Mr. Cox stated that he will reserve his argument for rebuttal.
That's correct.
The state believes that the bond as is currently set, that was set by the magistrate at $150,000 is appropriate for the offense, appropriate for the facts and circumstances around the offense. If the court were to lower the bond, the state would ask that there be a GPS with the waive of fees.
All right, defense, what are you requesting?
My position, Judge, when the state says that based on facts and circumstances, Judge, and I know the court may be aware based on the statements made on yesterday. My client has spent 26 months incarcerated in jail. In terms of facts and circumstances, the state had ample opportunity to address, look at, make determinations on any facts and circumstances. During that 2-year period of time, it wasn't a situation where every week we're coming before this court, pushing the state to make decisions. It was ample time to make this. And the decision that was made was to reject the murder case, and to file the burglary case, basically on evidence that there's a print on a safe. And if you look at inflation, the reference to the print. Can't put a timeline. On when a print is placed. So my position, Judge, is that you can't use a case that they can't indict, because the indictment, they only need proper cause. They can't base, try to get a court or convince a court to increase a burglary case to basically limit $150,000 on the burglary case. Because I practice in this county for more than, what, 30 years? Never had a burglary case where there was $150,000 bond.
What are you asking for bond?
I'm asking, Judge, I'm asking in the vicinity between 30 and 50.
All right, Mr. Romero, if you were to make bond, where would you be staying? All right, does she want you there? Have you asked her? All right, what is your grandmother's name?
Noemi, N-O-E-M-I. Chavez, B-H-A-V-E-Z.
All right, so Mr. Cox, so her address won't be blasted everywhere. If you will get the address from your client. This is what the court is going to do. And the court is aware of the capital murder case that was dismissed. The court is not considering dismissed cases in setting a bond. The court is going to set your bond at $65,000. Mr. Cox, if for some reason he's not able to make that bond, then we can come back and you can always file another motion for a hearing.
Yes,
I'm going to order full GPS. If he ends up having employment, then the court will, of course, take that into consideration, but it'll be full GPS for now. And waive fees. Yeah, I'm gonna waive fees.
But and just responding to that, Judge, is that my client does not have an extensive criminal past.
Right. No, I've reviewed that, but if he has employment, then the court will start you off with, you're allowed to go to work. And then if there are no violations, you can always come back and ultimately it may end up with tracking and ultimately may end up being removed. But for now, we'll start off with GPS. He's to stay with his grandmother. And your attorney can always come back and file other motions for me to reconsider. And you to reside with your grandmother. Is there anything else from either side? All right, so now with regards to this case. If this were going to jury trial, how long would it take, State? Do you have any idea? You're still,
I was looking at it when I was reading through it yesterday and this morning, I probably say about 4 days. Including 4 or 5 days. From the state side.
okay, could I see that? All right, Ms. Ferguson, on this case, I'm gonna need a jury trial setting and a plea deadline date. Yes. And if there's some discovery issues, you all can come in before that date.
February 21st.
All right, so we'll be back on February 21st. If you're not released from custody, they're going to bring you over dressed for trial in whatever clothes you have at the jail. So if you want to be attired in something differently, you have to do a clothing exchange with your attorney. If there's an issue with the clothing exchange, if he's not released, let the court know. All right, thank you. All right, the parties on Carlos Martinez. Court is calling 2017 CR 7730 State of Texas versus Carlos Benedicto Diaz Martinez. Could I have parties announced for the record for the state?
Oscar Salinas for the state of Texas.
Defense?
Brandon Lopez for Mr. Martinez.
Counsel, I'm showing you the discovery acknowledgement. Did you receive all the discovery in this case and did you review it with your client?
Your Honor, yes, we did.
And are you Mr. Martinez?
Yeah.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you weigh the reading of the indictment?
I waive reading, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge. I think it's less than a grammar.
No, this is burglary of a building.
Oh, my.
That's okay.
Yes, Judge.
All right, Mr. Martinez, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of burglary of a building, attempted burglary of a building force? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, you don't have to, the court doesn't have to follow that agreement. All right, just one moment. The document sheet says attempted burglary, but I think from reading the indictment, this is just a burglary of the building. Is that correct?
I believe so.
Is
I
it
got a little
attempted?
confused. That was the first I heard of that.
Yes, because attempted is not a state jail. All right. Did you understand you're charged with the offense of burglary of a building? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement, the court doesn't have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you are giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
No.
Counsel, has he been allowed to or had time to confer with the immigration attorney?
Your Honor, this is the case that had gone up on appeal and was remanded. He spent some time in ICE. I've spoken with his appeals attorney, Mr. Jimenez. I've spoken with my client who's talked to an immigration attorney with the Texas legal aid, and I've spoken with the immigration attorney. We're comfortable with the plea bargain as it is, and it undoes the issue we had when it went back to appeal.
All right. And so has your client been advised of the consequences of pleading no contest or guilty in the application of federal immigration law with regards to this plea?
Yes, Your Honor.
And did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes, Judge.
Do you believe he understands the consequences as it relates to his immigration status and entering a plea?
I believe he has a very good understanding of that. Yes.
Mr. Martinez, were you advised of the consequences of entering a plea in this case as it relates to your immigration status? Did that advice include possible consequences such as deportation, exclusion from the United States? All right, and denial of naturalization? And the denial of naturalization, did that include that? All right, and do you understand the consequences of entering a plea bargain as it relates to your immigration status? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 6 months in the Bexar County Jail under 1244. The state will take in consideration County Court Cause number 694774. Did you understand that to be the agreement?
Yes, Your Honor.
Defense?
It is, Your Honor.
State?
Yes, sir.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, state officer goes to Market State Exhibit 1 is attached.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand today that the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. Court will accept into evidence states exhibits 1 and attachments and review the same. And I'm sorry, what plea? How do you plead? No contest? All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right, Mr. Martinez, what is your native language? All right, have you been able to understand everything?
Yes.
Did you need an interpreter at all?
No.
All right, and counsel, have you been able to converse with your client in English?
I have, Your Honor. At the beginning, I was questioning it and speaking with his former attorney. He thought that maybe he was Spanish, but after talking with him time and time again, it's pretty clear that he understood, 95 to 100%.
All right, well, the court will follow your agreement, sentence you to 6 months in the Bexar County Jail under 1244, give you credit for any time served, taking consideration county court cause number 694774. Is this a judgment satisfied?
Your Honor, he has well over 200 days, yes.
All right, the court will find that the judgment is satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
No question. I am.
All right, good luck to you.
Thank you.
We'll be submitting the dismissal shortly.
All right, thank you.
Thank you.
Thanks.
Thank you, Judge.
You're welcome.
Mr. Freeman?
That's done.
Ms. Freeman?
All right, and everyone, just give me a moment. I'm going to take a short break, 10 minutes. And then we'll take the pleas that I have.
I see that. Yeah, she here, she.
She's in the back, officer.
Just about the time, would you let me come back after the first of the year to go
Sure.
Appreciate it.
Mhm.
Sign here.
Each version of.
I gotta press.
I thought it was too.
I know.
A murder set for here for Monday.
Here, here.
In case I wasn't clear, I'll start.
They don't have first check.
There'll be someone here.
There'll be someone that will know something about it.
Mhm.
This is sign here.
Yes, there will be.
Okay.
Pennies, it's Christmas time. Miracles have been known to happen.
No, because if they weren't, then
No, there'll be someone here.
I was gonna make an inflation joke when you mentioned that you've never seen $150,000 bond on a burger case, but inflation, it's gone up a lot. Yeah.
So they should give people 5 for 1 instead of 3 for 1.
That's true, right? Let inflation work the other way.
You should get out tonight. It's like tomorrow. Might be Monday, close to be tonight. I'm gonna text with your wife. I'll tell her that if you're not on Monday morning, they'll let me know.
All right, after we do Gilliland, then we're gonna take up Esperanza Marino. Are you here for Marino?
Yes,
Thank you for your patience.
you know what, Judge, I've been running back and forth, so. Get to me, when you get to me, I've been doing, finally got done with everything else.
Okay.
Questions? That's right. Sign right here.
She showed up, but he didn't.
In both cases, Judge, the plea bargain is the same.
Okay.
We've already filled out the probation data form. Or this one, want to start reading?
Are you here?
Want to start reading?
Yes.
Oh, sorry.
All right.
What is your name?
All right, can I see Mr. Gilliland? Okay.
Mr. Hernandez, just a second.
All right, the court. Oh, where's his other case?
I'm prepping there right now.
Okay. Neil Kappa said he's doing a plea on that case.
He lost one part better than the other. Which side is it? It's not this side. Oh, yeah. You like the other side better? Isn't it really boring? There's money or whatever they're fighting arguing about.
I need a third time, but already
All right, court is calling 2020 CR 4853 and 2022 CR 0067A, State of Texas versus Donald Joe Gilliland. Can I have parties announced for the record for the state? Defense. All right, counsel, in each of the cause numbers, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Mr. Gilliland, in each of the cause numbers, did you review the document entitled Application for Community Supervision and sign it and review it with your attorney?
Yes, sir.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Gilliland, in each of the cause numbers, did you review the document entitled True Bill of Indictment?
Yes, sir.
And did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments
Yes, Judge.
as presented in each cause number? In each of the cause numbers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, sir.
In cause number 2022 CR 0067A, you're charged with the offense of fraudulent use of possession of identifying information, 50 or more items. And in cause number 2020 CR 4853, you're charged with the offense of fraudulent use or possession of identifying information, 10 or more elderly. Each of those cause numbers are first-degree felonies. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have plea bargain agreements, the court does not have to follow your plea bargain agreements. If for any reason the court does not follow your plea bargain agreements and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand? Did you understand by entering into the plea bargain agreements, you were giving up those rights? And did you intend to give up those rights and enter into plea bargain agreements in these cause numbers? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Gilliland, has anyone threatened you, coerced you, or placed you in fear to get you to any of these pleas? Anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, sir.
In each of the cause numbers, the state is recommending community supervision. There are no applications for deferred adjudication. There's a $1,000 fine, 6 years in the prison. The state recommends community supervision. The cases will run concurrently. The state will take in consideration 2020 CR 3553, 2022 CR 0066, 2022 CR 0068A. There's to be restitution to a Mercedes Diaz and Cornelia H. Prisci, CRISCI. And there's to be restitution payable to both and no contact with both. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes.
State?
The only thing that I would like to add, Judge, or like to just clarify is that in the event that there were an additional victim or complainant that arose out of the facts of this offense, that the state would be allowed to have an opportunity to have a hearing to add that restitution to his current probation. I don't know if the court would be amenable to that. Again, these are the two complaints that we have right now at this moment who articulated what their restitution is, but if there were more, we would like to have a hearing.
State? I'm sorry, defense. With regards to adding,
That's, I'm. That's, I mean, as long as we can have a hearing first. Yes.
all right, so that needs to be put in the plea bargain agreement, because as you all know, it's parole evidence rule. So what is it ever is in the agreement is in the agreement. All right, so Mr. Gilliland, did you understand that if there are other complainants that arise out of these cases, that the state is requesting that restitution be given to them under these cause numbers? Do you understand?
Yes, sir.
So that doesn't mean that the state will be filing new charges. It means that the restitution amount for those complainants will be placed in these cases. Did you understand that?
Yes, sir.
And are you in agreement with that?
Yes, sir.
Defense?
Yes, Judge.
All right, did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it and did you sign it? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
And each of the cause numbers outside the agreement, the state is asking that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution in CATs 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? And cause number 2020 CR 4853, how do you plead? Guilty, not guilty, or no contest? And cause number 2022 CR 00678, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Judge, state move to admit listed market states exhibit 1 is attachment.
We have reviewed the same and have no objections.
All right, Mr. Gilliland, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty in each cause number, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, please.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it.
All right. In each of the cause numbers, the court will sentence you to 6 years in the prison, suspended and probated for 6 years. I usually give people CATs 1 and 2 myself, but I think you deserve it. But as a precursor for that, don't take what doesn't belong to you. You understand? So in each cause number, CATs 1 and 2, $1,000 fine, probated. Each case numbers will run concurrently. Taking consideration 2020 CR 3553, 2022 CR 0066, 2022 CR 0068A. Restitution, if any, to Mercedes, Diaz, and Cornelia H. Creasy. Restitution, if any, to any other complainant related to these cause numbers. So what that means, Mr. Gilliland, if there are some other documents that are in evidence that are related to this case and they have restitution, that's going to be your restitution. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring that, but if you do, 40 of those hours will be waived. Do you have any children?
She's old, grown.
Okay. Any drug problems? Then why are you stealing?
We pled no contest.
All right. So why is he alleged to have been stealing? I mean, is there a uncontrollable urge to
No.
take what doesn't belong to you?
Our position is that he was assisting another individual with a computer, and there were some issues with the computer that he wasn't aware of. However, understanding the risk, he chose to not contest those charges.
All right, there should be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month. Probation, if you want to consider that field visit as reporting, you can. Proof of employment within 30 days of release. There should be no employment as a home health care provider or with minors.
Judge, would you substitute full-time student for employment? He's planning to go back to school in the spring.
We'll cross that bridge when we come to it.
Okay, thank you.
All right. Is there any thing else with regards to sentencing?
No, Judge.
All right, probation, is there anything else he needs?
No.
And each of the cost numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because these are felony convictions in each of these cause numbers, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, Judge.
You're
You're
welcome.
excused.
Yes, and State, do I have those dismissals?
No, Judge, I'm gonna have to send them through Adobe. We ran out of them down here.
Okay, no problem.
She said. Thank you. And I'll see you back on that other guy.
Oh, yeah.
Well.
Yes.
Oh, thank you.
Yes, thank you.
Poor guy. I was in here that day. Yeah.
Yeah, and I was like, no, I can't have that.
All right, thank you.
All right, I'll take up the next case, which is Marino. Thank you so much for your patience. CRM. This one goes. All right, here you go. Yes, you can recall it for Monday. And is this client in custody or on bond?
I'm on.
All right, are they here?
Yes.
All right, Ms. Medina, we're gonna recall you for Monday. Is her attorney appointed or?
Hi.
Okay,
Jessica Medina? Yeah, for Monday. No, ma'am. Come in on Monday.
all right, the court is calling 2022 CR 9443, State of Texas versus Esperanza Marino. Could I have parties announced for the record for the state,
Oscar Salinas.
for the defense?
Valerie.
All right, I'm going to show you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, we have.
And are you Miss Marino?
Yes.
I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Court will find that the state is in compliance with discovery. Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, I'm sorry, counsel, do you weigh the reading of the indictment?
Yes, we did.
State, are you proceeding on the indictment as
No,
presented?
No, Judge, we're waiving the count one, proceeding on count two.
Any objection?
No objection.
All right, I'm showing you what's entitled court's admonishment. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? All right, did you understand the state is proceeding on unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea, this is done? You are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, she was. And
Miss-
she is.
Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Maria.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea bargain agreement, punishments be assessed at 2 years in the state jail facility. There's $1,000 fine, no application for deferred adjudication, and the state recommends community supervision. Did you understand that to be the plea? Defense,
Yes.
state,
Yes, sir.
showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motion? Next, I'm showing you outside the plea bargain agreement. How long are you all requesting for community supervision? No, I mean for, I'm sorry, not communities. Yes, for
Oh, yeah.
community supervision.
Oh.
Yeah, 2/2. Sorry.
That's okay. Outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 2 years. That there be 200 hours community service restitution, TAP evaluation, and CATS 1 and 2. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, sir. State offers was to mark as State's Exhibit 1 and its attachments.
No objection.
All right, Ms. Marina, I'm showing you what's entitled waiver, consent, and stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, it will be no live testimony? Did you understand? All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find the defendant guilty. The court will find the defendant guilty. Are we proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Your Honor, Ms. Moreno, we've been here a couple of times. You've amended her conditions because she's been doing an amazing job. It's a different person from the day that I met her. So we would ask that you follow the plea offer and agreement. She is on a GPS partial right now, so she's looking forward to moving on and doing whatever it takes to successfully complete her probation.
All right, when you're drug tested today, what are the results going to be? And you are going to get drug tested today. All right, have you ever used any drugs in the past?
Yes, in the past.
Yes, what have you used in the past? And what else? All right, we're going to do a drug test today. Do you have any children? What are their ages?
14 and
And do they live with you?
they live with my dad.
Okay. And who is this other person who was in the vehicle with you? What are they to you? Are you employed? What do you do?
A medical assistant and our driving associate.
Okay. All right, the court is going to, as previously stated, find you guilty, sentence you to 2 years in the state jail facility, suspended and probated for 2 years, $1,000 fine, probated, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes, the remaining of the hours will be waived once you complete the parenting classes. There's to be regular reporting by Zoom or in person. There's to be regular UAs. I'm going to want a UA today. CATS 1 and 2. Usually I give people that course, but I give the course, but I think you may need CATS 1 and 2, but do not take what does not belong to you. You understand? Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with Conrad, Adrian, Vidari. I think it's Vidaurria. I'm going to want field visits. one time per month. And probation, if you want to count the field visits as reporting, you can. Probation, is there anything else she needs? It can be either or. Is there anything else you need from me in order to be successful on this probation? State, do you still want her on GPS or can that be removed?
No, they can-
All right, and we'll remove the GPS. You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in both places? Right. Did you understand? Because this is a plea bargain agreement, because I followed your plea bargain agreement, it's been a long day. And because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you. Do better. You have children who are depending on you. All right, thank you. Thank you. Yes.
Thank you.
Court is calling 2022 CR 8640, State of Texas versus Roland Hernandez. Can I have parties announced for the record for the state?
Oscar Salinas?
Neil Calvis on behalf of Mr. Roland Hernandez.
Are you Mr. Hernandez?
Yes, sir.
All right. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, ma'am, I have, Your Honor. Yes, ma'am, I have.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, sir.
All right, Mr. Hernandez,
I'm waiving, waiving individual accounts.
that's okay. It's been a long day. Any objections to the waiver?
No, ma'am, Your Honor.
Mr. Hernandez, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, to both.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
Oh, Your Honor.
Has anyone promised you anything other than the plea?
Oh, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility. There are no applications. If you do not appear at sentencing, then you will be subject to the full range punishment. Did you understand?
Yes, Your Honor.
Defense, is that the agreement?
It is, Judge.
State?
Yes, sir.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No, ma'am, Your Honor.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, sir. State offers within Marcus States Exhibit 1 is attachments.
No objections, Judge.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. When are you asking for sentencing?
Just after the first of the year, Judge, any day, whatever the court pleases.
All right, Ms. Ferguson, do we have a time on the 9th? All right, so your sentencing is going to be on January 9th. They're going to give you a reset form. You need to make sure you appear on that date. You understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing, Mr. Hernandez. This is possession less than a gram case, which means, or I'm making the assumption that somebody's using. Don't go out there and start using drugs because you're not going to be seen till January 9th. Drugs are not approved by the FDA. People put in whatever they want to put in, and you could end up ODing. And then you won't make it to see the new year. It always gets to the point when it's close to the new year and people are knocking, as my grandmother would always say, knocking on the door, get into the new year, and then something happens and they die. Don't let that be you, because you're adding to the equation of using drugs. You understand?
Yes, ma'am.
All right, so Ms. Ferguson will give you a reset form and we'll see you back then. Always good seeing you, Mr. Kalfas.
You too, Judge. Merry Christmas to you and the court staff and and your mother, of course.
Aw.
So I will catch up with you. I'm sorry I'm the best friend, but
You have not been,
you know that if you ever need me, I'm right there for it.
see, that's the key. If I can pick up the phone and call, I know I can pick up the phone and call.
You know that you can, so.
And then you won't fly to get to me. You'll run because you could get there faster running than flying. It's always good seeing you. I had a chance to speak with Laura Abib.
Yes, well, how's she doing?
She's doing great.
What I think about is that it's been 25 years now since we graduated from law school.
Oh,
I'm
my-
not really sure where the last 25 years has gone.
Quite quickly, right?
I'm definitely not feeling like the new or young lawyer.
Well, just think of your first law school exam.
Well, I wake up in the sweats when I think of that, and when you laughing after.
All right.
How would you feel if you would have completely discouraged you from going into criminal law as a result of that?
I would have brought you along. I would have brought you along. I would have lifted you up.
Whether you know it or not, you did bring me along.
All right. Thank you so much for coming. So we are done for the day. We're going to be back on Monday.